authority. And what is important is this is the importance of blockchain is that each transaction is cryptographically secured, time-stamped, and linked in a chain of blocks, ensuring that once recorded, it cannot be altered without consensus across the network. So basically, what cryptography means is this is the science of protecting information using mathematical techniques to ensure five things. One is the five main features of cryptography is this, and that is why it is so important in a blockchain is confidentiality, non-repudiation, integrity, adaptability, interoperability, and authentication. So as I said, that take the case of Ramu. So when you now the system in the blockchain system, what is likely to happen is like this. Then when you register a document, the moment it is registered, a copy of the deed, or more precisely, a unique mathematical fingerprint of that deed, which is called the hash, is simultaneously written into 1000 registers wherever it is required across the board, and also in the national informatics centers and all other places. And the crucial part of this, the beauty of this is that no single entry in any one of these registers can ever be changed unless every single one of the 1000 registered agrees to the change simultaneously. And since they are all independent institutions with independent interests, that agreement is, for all practical purposes, impossible. So this is what is blockchain. So in the blockchain, I have just dissected it to four parts: blocks, chain, distributed, immutable, which I have just tried to by way of example, I just to say. So in a block, you have a unique mathematical fingerprint, which is called hash. A document is with date stamped, an order when the order is passed. Then you come the chain, comes the chain. So each block contains a fingerprint of the block before it. Then when it is distributed means that the chain is stored simultaneously on hundreds of independent computers. And immutable means once written, a record cannot be changed, not by the person who created it. Then I come to the next slide. So blockchain's four answers to judicial administration. This is very important. So I have given challenge, blockchain solution, and the impact of this. The first is that it is immutable timestamping. Every document carries a cryptographic proof of its exact state at the moment it was created. Secondly, audit intensive process, as I said, an automated audit trail. Every action on every record is permanently and instantly visible to any authorized party. Thirdly, it gives us distributed verification. Truth is no longer the property of a single custodian, it is a consensus of the network. And then smart contracts, which basically means that when a condition is met, the next step happens automatically without any human intervention. Now, as I said, go back again to Ramu. So in Ramu's case, suppose we have a blockchain system. So once his father may have purchased the deed in 2003, say for example, so he went to the registry office. So as a part of the registration process, it creates a cryptographic hash of the entire deed document and anchors it on permissioned blockchain. The blockchain records this document with the exact content was registered at that exact time, at this office, at this register. So that entry is permanent and it can never be altered. So please show the next you have explained is next, yes. So what happens in a blockchain system is that the court officer opens. So when in 20 say 2025, Ramu's neighbor filed a case and said that yes, it's I have a sale in my favor. So in a blockchain system, what the court will do? So in a blockchain technology, the court officer, the judge who is there, he opens a verification portal. There is a verification portal. He opens it and enters the document registration number. In 10 seconds, the system retrieves the hash of the document as it existed on the day of the registration. The court then runs the same hash function on the document the neighbor has produced. So he has two set of evidence. The hashes do not match. So unlikely that what is going to happen, or rather, if we go to the conventional way of proving this document, conventional proof of document, the hashes are different and we need to investigate further, and there appears to be some discrepancies. These things are being taken care of when we go by this kind of technology, because now if the court finds that the hashes do not match, then in a second he can say that this document is not proved. Similarly is the case of this another instance I've given is a motor accident claims. Similar thing happens that in a blockchain technology you need not this insurance company give the next please next slide. So in a motor accident claim case also, that whether this policy is valid or not, whether the premiums is paid or not, hospital records are not available. So when we go by this, we apply the blockchain, the entire history, the if it is the now the every motor insurance policy in India is now hash sealed on a national blockchain at the moment of issue. So everything is clear with regard to the policy premium paid. Similarly, with the vehicles history, you can have in the Vahan blockchain, and also hospital records are anchored on blockchain at the time of treatment. FIR is hash sealed on a police station without also registration. So you have the exact content of the FIR at the time when it was registered. So it is easier for now a judge deciding on a motor accident claim case that he opens a single unified portal and she queries that insurance policy for this vehicle on this date. The system responds in seconds. It gives entire thing. And the beauty of this is this that none of this insurance company not going to know what is there, what the judge is saying. So there is no third party involvement as such. The portal will speak for itself, and as a result of this, even the apprehension that may be there that whether this will be getting a divide, because Ramu, for that matter, the person who has suffered the accident, they are not required to go into this because the portal will speak for itself. Uh, So you can come to motor accident victim. This yes, this is the one. Now, before and after the blockchain, as I this also have explained, unified. We can omit this. Now, evidence custody. So this is just this four things speaks for itself. That investigating officer photographs and log evidence. There is a QR code generated. Digital record is created on blockchain with GPS coordinates and timestamp. Then Malkhana entries, similar evidence is entered in the Malkhana blockchain records, the exact time the officer responsible, and the hash of the evidence photograph. Then forensic lab on transfer FSL, both the sending officer and receiving scientist digitally sign the blockchain entry. Any tampering is immediately flagged. And court production, when produced before the court, the judge can scan the QR code, see the sample unbroken custody chain, every hand it passed through. So there is no chance of any, uh, as such, any tampering. Now, judicial change, and this is just, I think if it's required, I'll come back to this, but these points I've more or less covered in my presentation. Is a summary of what I said. If required, I'll come back to this. Now, smart contracts, I think during the course of discussion, this will come. As I said, that smart contract is a self-executing rule written on a blockchain. So this helps in a number of ways. I just flag few things of it. So how the smart contract can have a transformative role. So first, it enables an automated chain of custody by using smart contracts to log every action taken on evidence with immutable timestamps and digital signature. Second, it guarantees real-time authentication via ledger databases that sequentially record data without erasure, providing a universal source of truth for distrusting parties. Third, it ensures coherent intercode and interagency sharing, allowing for customized disclosure and preventing unauthorized interference during the transfer of sensitive data. And fourth, smart contracts can protect sensitive evidence to zero knowledge proof protocols, which allow for controlled disclosure where data appears redacted to the public but is fully accessible by the authorized judges, as I said. So additionally, smart contracts can also detect if there have been any manipulation with the evidence due to their hashing and time-stamping methods. Lastly, these smart contracts are cost efficient as well. Now, uh, this is these are some of the judgments we can omit for the time being. Where this technology has been, the Supreme Court time and again has said blockchain in land matters and other matters also. Uh, in fact, in this Arjun, in Arjun Khotka's case, the Supreme Court, we can draw an inspiration from this judgment. We can model rules should be framed. I would suggest that model rules can be framed, should be formulated to address the admissibility of blockchain anchored records, metadata preservation standards, and legal presumptions of integrity. These rules should provide the normative clarity needed for uniform judicial practice across jurisdictions. Now we can go to the next slide. Globally, I've given a global picture of what is happening. All of this mostly will find that so far as the land records are concerned, they are using this blockchain technology. Now, these are the legitimate concerns. One of these I have already said that in case where I said that whether Ramu is supposed to know about what is happening, as I said that it may not be required because the entire system is such, it's modeled in such a manner that the judge who is having the portal before him can have an access to this. So four things. So what about digital divide? Rural litigants cannot use blockchain. So blockchain operates at the back end. So court and agencies interact. Litigants need never know. This is the two cases I have referred to right now. Now, what if the data entered at source is this is a very vital issue. So if the data entered is not entered properly, then what would happen? Now, it's really a fair concern because the blockchain guarantees that what is recorded cannot be changed later. For accuracy at source, we combined it with biometric linked authentication and multi-party verification at the time of entry, similar to how other linked processes work today. This can take care of this concern. Third is it too complex for our existing infrastructure? A permission blockchain, that is most important. A permission blockchain such as Hyperledger Fabric, which is what most government applications use, integrates with existing system through standard interfaces. It does not require replacing CCTNS or WAN. It sits, it sits on the top of them, adding the layer of immutability. And what about the privacy of the litigants? That is another concern. But as I said, that permission blockchains enforce role-based access. A MSCD judge sees insurance and medical data for that case. The insurance company cannot see the medical record. The hospital cannot see the vehicle registration record. Details privacy is enforced not by policy. What can be overridden, but by cryptographic architecture we cannot. This where I end because these are the roadmap. I propose quickly we can go through this. I'm not reading it out. So these are uh, the we require awareness, demand verified evidence, engage with the executive. So as I said that in conclusion, I will say that blockchain solves the four structure failures of judicial administration. It makes every document, every signature, every transfer permanently verifiable. MSCD victim gets compensation in weeks. India has the digital infrastructure, e-courts has the framework. We need the judicial will. The chain of trust begins in this room. Thank you.
Uh, Thank you very much. Chief Justice Soumen Sen has made a very, very exhaustive, elaborate presentation on what blockchain technology actually is. So I'm sure the participants here and the panelists will have very, very, very many interesting questions to answer so as to demystify the technical angles of this concept of blockchain. But before that, may I request Chief Justice Sandhawalia to very briefly make his presentation so that we can carry on with the morning session.
Morning, my panelists on board, other members, everybody who has joined from all over the country also. The chair has kind of explained and tried to summarize the issues which we are here to discuss. Of course, there will be a certain overlap also, and the moderator is already pushing me into a corner and saying that the repetition might be there. But I think that is a little factor which, because the issues are common, and the more we discuss amongst us, That is the important aspect, how we have to go proceed in the future. Even when the concept of blockchain, slide 2, the concept of blockchain is introduced into public discourse, it is frequently accompanied by a litany of associations. But within the context of judicial administration, state governance, the technology is representing a fundamentally different paradigm. Now, whether judicial administration can successfully transit from the paper-dependent interpersonal trust to this mathematically verifiable trust is the issue. Despite decades of ongoing computerization, much of the global justice system continues to depend on workflows that I would say are fragmented. They are manual, heavily reliant on physical registers, and intensely audit prone. The tracking of case files involves multiple and often disjointed platforms. The example of issuance of certified copies are demanding absolute confidence in both the issuing authority and the document's authenticity. Slide 5. The handling of physical and digital evidence would require an unbroken and an unquestionable chain of custody. Process such as bail and prisoner release demands both urgent speed and absolute certainty. Currently the Indian judicial system, says slide 7, is facing a staggering backlog. The Indian judicial system is a high courts lies at 45 lakh cases and nearly 4.71 crore cases currently pending and raised all district courts in India as per the data. Cases are getting delayed due to missing files, unavailable witnesses, or procedural disputes regarding documents' authenticity. So what we need is a trustworthy shared digital record that is exceptionally difficult to tamper with, entirely frictionless, and to verify. And the blockchain should not be viewed as a passing technological fashion or a hollow slogan, I would say, or a wholesale replacement for the existing judicial software. Rather, it's going to be function as a foundational trust infrastructure. And slide 11. At its core, the blockchain is a method of maintaining a shared distributed ledger in which entries, once accepted and cryptographically sealed, become virtually impossible to alter secretly. It will create a chronological chain of verified records bound together by timestamps, cryptographic signatures, and linked mathematical histories. Number 15. Courts normally rely on traditional databases for their primary operations, generating calls, managing vast archives of pleadings. However, a traditional database typically possesses a single point of failure, a system administrator with sufficient privilege, or a malicious actor who breaches the perimeter can alter a record without leaving an obvious trace. So 16. Now the issue is, as Brother Sain put it, Ramu, the example given. Now, did a specific forensic document exist at the precise date or time? Was a release order digitally signed by the competent judicial authority, or is it a fabrication? Is the version of the judgment being acted upon by the prison identical to the version originally issued by the court? Was the custody of the forensic evidence transferred from investigating officer to the laboratory without a break in chain in criminal matters? Was a judicial notice genuinely dispatched, received by the relevant party? These are the issues which we can deal with successfully with this blockchain issue. Now, if you, slide 17, the advantage and the features that have been highlighted in this between an blockchain augmented administration, the traditional manual administration, I would say. The features would be record keeping, integrity check, authentication, efficiency, and vulnerability. The 18. Earlier, in medieval times, wax seals were used to close deals, prove identity. They were vulnerable to forgery, tampering, tending to a long history of legal fraud. Now, we have to give a public key as an unlimited supply of identical open padlocks that the judge makes available to the world. The private key is a unique, uncopyable physical key retained exclusively by a judge that can unlock the padlocks. 21. This mechanism will allow anyone to send a secure message to the judge by locking it with the public padlock, and only the judge can open. So this is, in sum and substance, the how the system should work. The participants, I would say, slide 26, would include the Supreme Court and the High Courts, district courts, state police departments, investigating agencies, prison and correctional authorities, state forensic science laboratories, the prosecution departments, treasury or fine collection interfaces. It's within this ecosystem that no participant is anonymous. Every action will be institutionally traceable and bound by legal framework. As Brother Sen just now pointed out, the registry or the sale deed, whether it's the hash is matching or not, that is how by the court would be able to examine. Otherwise, whether the document or the sale deed was forged, it will take years, and evidence, whether the witness is there or the person who attested the document, whether he's died. There's so many other issues on this. Slide 27. For example, when the police files a first information report, its hash and metadata are committed to the chain. When the court will issue a summons based on that FIR, the court will read the trusted state from the chain. When the prison releases an under trial, they verify the bail order against the court's immutable signature on the same chain. This transforms interinstitutional trust from a bureaucratic hurdle into a verifiable mathematical reality. We can give examples of forged court orders, 34. There have been examples of one Dhaniram Mittal. He is a prolific car thief and assumed a magistrate's identity, presided over a court also for months. He sent people to jail. Then there was this Delhi High Court Komoto intervention in 24 also, when a person facing severe human trafficking charges have been heard and reserved for judgment. There are several cases of Bijnor prison release fraud. The collapse of the evidentiary chain of custody is 36. Was the case in the Arushi Talwar double murder case, when the issue was when evidence was collected, by whom, where it was stored, when it was transferred, and whether the seals were intact, whether any later version different from the original. So these are the legal lessons which you have to learn, that when the chain breaks, the doubt enters. And when the doubt enters, conviction becomes unsafe. The blockchain is relevant because it's designed to make such chains harder to break silently. Blockchain does not replace judicial appreciation of evidence. It strengthens the administrative integrity or evidence handling. 38. Every transfer of forensic evidence is fraught with risk. The life cycle of evidence, who collected it, who sealed it, who transported it, who received it at the laboratory, at what time and under whose authority, can be securely digitized via the blockchain. In NDPS cases, this is a major line which has to be meticulously followed regarding even taking of samples. The utilizing platforms like interoperable criminal justice system, investigating officers can upload digital photographs of sealed evidence at the crime scene, immediately hashing the image and metadata to the blockchain at the time of investigation. 40. For court verifications, like if a court orders a refund of a judicial deposit upon a conclusion of a civil trial, A smart contract can automatically verify the finality of the judgment. The conditions are met, the contract executes a financial transfer to the litigant's verified bank account without requiring manual registry intervention, reducing delays and eliminating intermediary costs. The courts have to not only protect the confidentiality, but they have to inspire public confidence. The public may not need access to all the content, but the public deserves the access to the proof. '42. Looking at the evidentiary admissibilities and aligning the technology with jurisprudence. A technological solution, no matter how elegant, is only viable if it aligns seamlessly with the statutory evidence law. In India, the admissibility of electronic records has historically been a point of heavy litigation. Section 65 of the Indian Evidence Act and the landmark rulings 43. Now, with the introduction of the BSA 23 from the 1st of July 24, it modernizes the evidentiary framework for digital society. Section 61 of the BSA provides a broad definition of electronic and digital records. Section 63 serves as the equivalent to old Section 65 of the Indian Evidence Act, regulating the admissibility of electronic evidence. 44. If a piece of digital evidence such as the CCTV clip or a financial ledger is hashed to the blockchain, at the moment of collection, any subsequent challenge to its authenticity can be immediately resolved by comparing the hash of the evidence presented in court against the hash anchored on the ledger. Come to 53. The risks and the cautions. 53. The garbage in and garbage out. The blockchain will not make a good data bad. If a corrupt official intentionally uploads a falsified forensic report, the blockchain will immediately record a lie. Upstream controls and rigorous access management would remain strict and necessary. Interoperability challenges different departments using different legacies, systems, schemes, and proprietary formats, developing universal adapters. Capacity building is also have to be seen. Judicial officers need not to become software coders, but all stakeholders from judges to registry clerks must undergo training to understand what a digital signature means, what a hash proves, and how a blockchain would strengthen the process assurance. I would now conclude 54 that judicial administration is at the very heart and exercise in a trusted process. The authority of the justice system would rely not only on the legal brilliance and equity of the judgments, but heavily on administrative pipelines that support these decisions. It would operate through files that must move correctly, orders that must be authentic, records that must be preserved, indefinitely physical custody that must remain continuous, and communications that must be provable. When these administrative handshakes fail, whether due to manual negligence, infrastructural decay, or deliberate forgery, public trust in the institution would suffer irreparable damage. The deployment of the permission blockchain infrastructure within the judiciary would represent an historic necessary shift. It would enable the evolution from an ecosystem that merely asserts its integrity to one that mathematically proves it. By allowing existing databases to remain highly functional systems of record while positioning the blockchain as the unassailable system of truth. Courts now will be able to eliminate the profound vulnerabilities inherent in physical documents and the siloed networks. As the Indian judiciary now advances through the phase 3 of the e-court projects, the integration of these technologies will prove pivotal. In the digital age, judicial legitimacy is linked to the process of integrity. Blockchains will thus secure integrity, ensuring the pathway to justice remains unbroken, transparent, and completely verifiable. With that, I ask the moderator to take over and carry the discussion forward. Thank you so much.
Thank you very much, sir. This was indeed a very informative presentation. Now, after the two very exhaustive and informative presentations by the chair and co-chair, it's now time for having some discussions, deliberations. About 40 minutes is what we are left with in this session. Now, we have, as you have seen, we have a very eminent panel which will be dealing with questions, some of which I will be putting and some of which maybe the audience may also like to say. But before we really embark on this journey, short journey, there are just two things I would like to mention here. You see, everybody present here, I'm sure, has got a fairly good, decent understanding of what blockchain really is. But in case there is someone who is still trying to figure out what blockchain technology is all about, in a very simple language, what I can say is that this is a technology which stores information in blocks. Each addition to hash value, that is, even a slightest addition to that information block, creates another block, and that is how it goes on. And all the blocks are connected through something called a chain. That is why the name blockchain. So, since you have information stored in millions of blocks, if you tinker with one block, that is not going to tamper with the information stored in the blockchain. That is why it is called decentralized. That is why it is called immutable in the sense that you cannot tinker with the information there. And that is what creates the trust architecture for which judicial institutions today are very, very intently looking at using this technology for furthering the cause of justice delivery system. That is the relevance of this topic in our present day situation. Blockchain technology is freely available, but what is required to run it is your own network, which involves some amount of cost and some amount of planning. So in the next 20, 30 minutes or so, we'll try to figure out through some questions and answers as to how we can possibly implement blockchain technology in the judicial system in India today and in every setup of the judicial system. Now, to begin with, may I now call upon Honorable Justice Basak to please enlighten the audience on the question as to how blockchain technology can contribute to judicial reforms in India by bridging the gap between access to justice and timely delivery of justice.
Brother. Thank you, brother. Good morning to everyone present. Uh, First and foremost, a big thank you to Brother Mustaq, Chief Justice, and to his team, entire team, for the excellent hospitality. So please, now that you are sitting here and enjoying this conference, it speaks volumes of the efforts that your team has put in. Thank you so much. Our gratitude to all of them. Now, coming back to this question, I'll just preface it and with a caveat of mine. My understanding is that technology is used to assist us, or in fact, I will not limit it to the judicial decision making authority. It's a technology which should assist each of the stakeholders in a judicial process. So, for unfortunately, to my perception, we are looking at a problem from the perspective of a judge. According to me, we shouldn't. We should broaden our horizon. We should broaden our uh, endeavor to inculcate every aspect or every stakeholder so that we have a seamless and a smooth system where technology assists in a justice delivery system in a time bound, cost effective manner. Now, having said that, we need possibly, again, adding to that caveat of mine, a kind of in-house introspection as to the quality of human resources we are having, which assist us. That is the registry.
maybe with the passage of time, we are looking at and should be striving to have persons with domain expertise in certain areas. We are not presently having that quality of human resources. I think it's across the board with all high courts. So we should get into a system, in structured system, so as to kind of revisit our needs so far as human resources are concerned. Technological aspects, it's a developing scenario. Every day there is new addition and an improvement. We can always get that on board. And coming back to this question, now access this blockchain technology contributing to judicial reform is something which is perhaps a given. We can, and two uh, speakers before me highlighted how this blockchain technology can be useful for a decision making process. I need not uh, enter into that arena. Suffice to say that it eliminates the re-verification burden by creating a shared tamper evident record accessible to any authorized institution. Then there's NIC's certificate chain, which already verified about 34 crores government documents, which we can utilize. Then can we, as a court, we can verify a document authenticity through a portal or a QR scan in real time, which does not need to await further attestation or ratification by the issuing authority. Now, these are some of the plus points or advantages. It's timely delivery. Order transmission delays are obviated. We have the fastest system. We can use this blockchain to go work beyond that faster system and get our orders transmitted to appropriate authorities for kind of compliances. Then we can look into this registry and the office process blockades and bottlenecks which we can overcome through this blockchain. Manual registers, file movement records, process service logs. These can be overcome. This pre-adjudicatory delays can be overcome through blockchain. Then this interagency data gaps can also be addressed. Now, since with the permission of the moderator, I'm putting this question for all of us to consider. This blockchain technology is this that you create a hash. Now, what happens to a decree which is amended? The original decree is uploaded. It's on a blockchain, and then it is amended
Sir,
as a
I'm just interrupting you for a moment. I think we have a question precisely on that point. So we'll throw it open to the House when that question comes. We are talking about using blockchain to obviate delay in execution of decrees, and that is where perhaps your question will be very relevant.
yes. If a decree is amended, then what happens?
Yes. Now, is that all with your answer
Yes,
to
sure,
this?
sure,
So
sure.
thank you very much. You have been very, very articulate. We'll have some follow-up questions and we'll invite comments from the audience as well. So to move on with, may I now request Justice Ananda Sen to please reflect on this question. Uh, is the present level of infrastructure in the court systems in India sufficient to implement blockchain technology? And if so, or otherwise, are simpler technological solutions available today to provide the similar result?
Thank you, Honorable Justice Suman Sam. Thank you, Brother Mustaq, Chief Mustaq, for giving this opportunity. The question, the infrastructure. Uh, India is a country of great digital divide, be it physical infrastructure or technological infrastructure. But, and this divide from south to north and east to west, there's a further fragmentation of division between the district courts and the high courts. When we are talking about blockchain, we have to understand this distributed ledger technology and what goes inside it. This and where is the data stored? What goes in the blockchain is the hash value, time stamping, and the document, the body and the header and the body. And where it is stored It is stored in either the clouds, you may store it, or you may store it in the NASH. So first of all, we have to have that infrastructure everywhere. Once we are talking about this distributed ledger system, we are taking ourselves out of this centralized system. So we have to say whether this distribution is well distributed amongst our district courts and our not only judiciary, the administration, whether the land records are there, whether the the insurance companies and everything. One, we have to be on the same page to effectively utilize this blockchain technology. So if in the court, as Justice Basak said, if we are sitting and we are trying to access a document of the registry, and if that registry department in a remote village, in a remote subdivision, is not properly equipped with the your servers, then it is very difficult to access that, and it will be absolutely a failure. So so for the infrastructure, first we all have to be on the same platform to get benefit of this technology, which I think at present we are not. We have to address this issue.
All right. Thank you, Justice Sen. You have very, very eloquently responded to the questions. Uh, Now we would turn to Mr. Vasava Prabhu Patil, the Advocate General of the state of Sikkim, who I believe will voice the concerns of the bar pertaining to this question. Mr. Patil, could you please respond to and enlighten the House if you think blockchain technology can help in efficient management of evidence within the ambit of Bharatiya Shakshya Adhiniyam 2023? And if so, in what manner?
Um, Distinguished chair and co-chair, distinguished co-panelists, and and distinguished members in the audience. I have a few thoughts before I respond to that question, though the chair and co-chair have extensively covered. Is it audible? Yeah. 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 I have a few thoughts before I answer the question. As I understand, blockchain is essential for judicial administration as a way forward for the reason dependency has become insurmountable. It is necessary to equip the courts with everything possible. AI and blockchain digitization is also one of it. So in this process, what does the blockchain do? It's a digital register. It's a trust technology. I say this is a trust technology because we find it very difficult to trust documents that come before the court or the speed at which it can be discovered whether the document is genuine. By having what we called permissioned blockchain, if the feeder of the data is given the permission and it is permissioned and it's put up, the courts can easily rely upon them and save judicial time. I believe this is the main reason to have a permission blockchain instead of a public crypto kind of blockchain. And it's also important to know that once you enter some data, it's very difficult to change it as it's not centralized. It's in several blocks. If you have to make a change, you have to make a change everywhere. So unless it's permissioned and it's carefully entered, any change becomes very, very difficult. I also feel that this is not going to be a substitute for judicial mind. It's only a tool for authenticity and not a tool for adjudication. Caution is equally important. If wrong data is uploaded, blockchain will only preserve wrong data faithfully. Therefore, verification at the point of entry is critical. The future use case is not replacing judges, it's strengthening the court registry, evidence management, order transmission, and interdepartmental trust. It definitely has great value insofar as land records are concerned. Everybody struggles today with the land records, the authenticity of land records, and the tampering of land records. If it is coming from a permission source, it's very easily accepted, and then we move on without wasting time. So also the transmission of the certified copies of the orders. I believe in Karnataka, they have verification of e-judgments through blockchain. Karnataka High Court website itself has a live menu option, verify e-judgments using blockchain. In simple terms, this allows a judgment copy to be checked against a blockchain-backed record to see whether it's authentic or has been altered. So I feel, going by the topic and the question, blockchain for judicial administration is very essential. It has three important participants. It requires a lot of funds, which states have to pitch in. It requires courts to adopt and adapt. So therefore, it's a long haul. It's not going to be quick. At least we should hope by 2030, we are in a reasonable shape and it facilitates quicker dispensation of justice. Thank you.
Thank you, Mr. Patil, for your very eloquent answer again. Now, ladies and gentlemen, as many would be aware here, in the Indian judicial setup today, there are many high courts which are trying to make significant stride by coming up with their own methods for integrating technology. But amongst all, arguably, Kerala High Court today is believed to be one of the high courts which has made significant stride in that direction. We have amongst our here today Mr. Joseph Rajesh KA, who is the CPC of Kerala High Court. And therefore, my next questions will go to Mr. Joseph. But before that, I just wanted to highlight once again that blockchain is a decentralized ledger which is immutable, and therefore the trust factor, therefore the trust architecture. But while answering the question I would like to put to you, could you please also highlight why a centralized ledger through other softwares cannot serve the purpose of the judiciary today? So my questions are twofold. Can you please tell us how blockchain technology can practically replace manual registers and physical file movements tracking in judicial administration without disrupting the existing workflow? And secondly, to what extent can immutable timestamping and temper evident records strengthen the tamper-proof evident records strengthen the integrity of the evidence custody chain in the courts?
Thank you, Milord. Before I go into this subject, I take this opportunity to thank Milord, the Chief Justice of Sikkim, Honorable Justice Mohammad Musak, for convening such a meaningful conclave and on subjects of utmost importance and relevance. And also, Milord, Honorable Justice Soumen Sen, the Chief Justice of Kerala, and other erudite participants in this. Very good morning to all of you. Before taking the questions, I will rather go into the subject in a very practical way as to how this can be implemented. We have a very extensive discussion on the legal and technological aspects of blockchain, but how it can be implemented in the judicial scenario is the thing that I think I will be touching upon and will be coming to answer those questions as well. So we are all in the judiciary are sure that blockchain is required because it is adding a trust layer to the documents or trust layer to the existing system. It is not going to replace anything, but adding trust, as Milord, the Chief Justice in the opening chair has pointed out, the trust factor which requires years or decades of times element required for verifying a document can be do away with once this is implemented. Then leads to the next question, how this can be practically implemented, because now everyone is understanding that blockchain is something that every document is through blockchain and it is transmitted to different nodes through blockchain. My proposition would be that would tell upon the budgetary things of the state and all organs participant in this process, which would be very impractical both on the side of finance and on the side of the ICT infrastructure. My proposition would be that let the central repositories that are handling the documents, records, may continue as such. But as a super layer, whenever a document is transmitted from one point to the other, let the hash, the cryptographic signature, be stored on a blockchain, which will have a less impact on the blockchain itself. And what should be the blockchain? The blockchain should be, as everyone said, it should be a permission blockchain, a private blockchain. Only the participants that are decided by the judiciary or by other agencies like investigating agencies, land records agencies, governmental agencies, and others who can only participate, and we will provide them roles, whether he can read only access or write access is provided. And whenever the document or records, whatever, be a video recording, audio recording, or a document is transmitted from one node to the other, they are not just storing it, they are only storing the hash value of that particular transaction, the particular document, and that is verifiable by the recipient. And if there is something happens, it is not tamper proof, it is just a tamper. It can be evident that it is changed or not. That is the only thing. So with that, this will be the mode in which it should be done, and a private blockchain is required for the judiciary as such, where there are open source technologies, Hyperledger Fabric, it is available. It is a low cost thing, no cost thing, which can be adopted, and it will not have any implication on the exchequer also. So this is my point. Thank you.
Thank you. But Mr. Joseph, blockchain, as I understand, is open source today. Only the network is private.
No, my lord. Actually, the blockchain technology used by the cryptographic currencies, like the networks, they are charging for each transfer.
No,
They
I'm not asking.
Yes.
The question is slightly different.
Yes.
Blockchain technology is being used in cryptocurrency. Cryptocurrency is a business and operation by itself. What is the fiduciary operating there? We are not going into it.
Yes.
What I'm asking is blockchain as a technology, it is open source. That's
Yes.
correct. But
Oh.
if you want to run it, you need to have your private network.
Correct, my lord. It
If
is
you want to
correct.
run it in judiciary, you have to set up your network,
Private network.
which we are yet to do.
Yet to do. That is
Correct.
correct. Yes. My
So we are talking about a possibility which is yet to take its wing.
Yes.
Is that correct?
Yes, my lord.
Okay. Now we'll go to the next question, which really is on the issue of interoperability of blockchain. And here I would request the members, the participants, the audience to please chip in. I can see Mr. Maithani already getting ready with a barrage of questions. He has been very active yesterday, and today also I believe he will be active. But before we move on to the next question, and Justice Karnik is also waiting to ask some questions, as we understand. So is Mr. Kariel, Mr. Michael Zothankuma, and last but not the least, Mr. Suraj Govindraj. But you see, there is a very interesting sphere of use of blockchain, the synergy of blockchain and AI, which is in the realm of something called IDS, Intelligent Decision System. I believe many of you must be aware. But just in case you are not, this era of smart contract has gone very far, where now IDS is operating. IDS is something where a smart contract housed in the blockchain network and technology, it can trigger itself and implement on reaching a particular milestone which is pre-programmed. Once that milestone is reached, the contract itself executes or cancels it, and on cancellation, whatever the possible litigation over over you know overburden on it gets automatically unfold. So these are functions which are happening purely on technology without intervention of any judicial forum. This is just to say how interoperability of these technologies can take things forward in leaps and bounds. But coming back to the question which Justice Bosak had flagged, uh, what is the impact of blockchain technology? Supposing we use it extensively in civil litigations involving property documentation, verification, is it going to substantially cut short the delay in execution of a decree? Would anybody like to give his thoughts on that? Yes.
But the,
Can we have the microphone?
when we say blockchain, it's as you rightly said that we are securing our authenticity of the documents.
Yes.
As far as the executability or the time duration for execution of a degree is concerned, perhaps it had less to do with that.
Okay.
Except retrieval of the documents. Blockchain technology basically to authenticate that it's on n number of network places systems.
Okay.
So you can't change, you can tamper. That's it. Security, integrity of the data. That's what my understanding about the blockchain is.
All right. All right. Thank you. Any difference in opinion there from anyone? Anybody would like to express?
I just want to say something. It is the data which you put in the blockchain. So you have to be secure the data which is going in the blockchain is the authentic and untampered data. Today, if a police investigator, as per the BNSS, he records a scene of occurrence and takes 5 days to upload it in the blockchain. In the meantime, he changes something, tampers with things. So what is going in the blockchain is a tampered data. So we have to take care of this also.
Yes, madam, you have something to say?
With my limited understanding, but I think we are talking about use of this technology in execution of decree. Correct.
Correct.
And a civil decree. Correct. So what my understanding is that you cannot go behind the decree. So at the stage of execution of decree, it will have very limited role to play when there is a third party intervention. When third party comes in at the stage of execution and says, suppose it says that I am in possession of the property, order 29 rule. Correct. Where the court is supposed to answer that question, and then only the question of use of this technology or for the purposes of verification of the documents would be needed.
That's
I
the
suppose.
precise point. In fact, you have touched upon a very, very relevant and important chord. Let me reframe this question a bit. I am asking this in the context of, say, let's say Section 47 of the CPC, which says all questions are to be left open.
Correct. Huh.
We'll come to it.
Huh.
You will have a very important answer to give. I think others would add. All questions have been qualified, if I remember, by adding the words execution, satisfaction, and discharge of the duty.
Right.
Now, supposing during the civil proceeding itself, if you mount your data in the blockchain, right? Blockchain is a manner of preservation of data. You can't say that tempered data is entered into blockchain. Whatever data goes into blockchain, that is what we are concerned, not what happened before that. So if you have all this data available, then the scope of section 47 is drastically reduced. Is it a possibility? Because the courts will not need to verify many things which are already on record in a temper
No,
proof.
I think
That's the
that
question.
that stage comes in when the parties who are not into litigation and they are not already party to the suit, they are coming up to the court.
Okay, so
So
that's one view.
that is the difference of otherwise the parties, if the parties are into litigation and their rights and are already adjudicated, they cannot, the court cannot relook to the decree. It has to execute it.
That's right. That's
So
thank you.
execution of satisfaction would be in a case of like partition decree, where there are meets and bounds partition are to take place. There may be some relevance, according to me.
No, no, that's very. Anybody else wants to?
If I can answer it this way, sir, at the stage of the suit, when a plaint is filed, the defendant always says this is false, this is concocted, this is a fabricated document. That requires a Order 16 Rule 6 application. Call the VAO, call the Tahsildar, call whichever officer is required. That is where probably the Advocate General could look into that there is a huge expense on the administrative setup. Those people are in court not doing their other work and coming to court and deposing on a particular document which is there, but because it is denied, this process has to go through. Now, this trusted layer which comes in at the blockchain level, if there's a verification system, today many of us use DigiLocker, we use DigiYatra. It's an identity document. We can walk into an airport, which is supposed to be one of the most secure places, showing our mobile phone, and we are verified and we go through that kind of a verification of a document. It could be a sale deed, it could be RTC, it could be a electricity bill, it could be a water bill, it could be any of those documents. If they are verified, the question of asking any officer to come to court will not arise. The speed increases automatically because summons to that officer, he may not be busy, it gets urgent. We see all these things. So those kind of things, definitely it will hasten up the procedure. Insofar as the execution that we are speaking of, there are different kinds of execution. There's a money decree, there's a specific performance decree, there is partition. It may not, one aspect will not fit everything. For example, it's a money decree. It's a money decree, you need to attach the bank account of that particular defendant. This execution can automatically, using a smart contract, trigger attachment of the bank account. It doesn't need to go through the entire process of sending summons, calling him, issuing that order, sending the order to the bank. What just Sandhawalia spoke about as regard the judgment, the bail order reaching the prison authority. The timing that he gave was 10:14. The order was uploaded. 11:02 it was reaching there. Within that 1 hour, the bank account could be attached. The attachment as a immobile property could be reflected on the land records within that 1 hour. So
Okay.
those speeds will come about.
Okay, thank you. Now we have amongst us here. We'll come to you. A very eminent legal juristic mind present here today. A deep thinking legal mind. Honorable Justice Arun Bansali, the Chief Justice of Allahabad High Court. We can't move forward possibly without getting a small bite from him on what he has to say on the discussions at the
So
moment going on.
same aspect as was being emphasized by Madam Agarwal regarding means it is the during the course of execution the issue will only arise if applications under order 2158 or 2197 they are filed, and they are normally filed by the third parties. So once the third parties enter into and claim the ownership or
Right.
something contrary to what has been decreed, claim right in the property, then already as to what has already happened during the course of the suit, that loses its significance. And everything will have to be then redone. The entire, because 2158 and 2197, both the proceedings, they go fresh as a suit again. So then, as such, as to what has already happened in the suit is of no significance insofar as these kind of decrees, any objections are filed in those cases. That
All
is
right.
the issue.
Thank you. Yes, I agree with you. Yes, Mr. Saldar.
I just wish to ask a question.
Yes.
Whether anybody can tell where this DLT, distributed ledger technology and permission blockchain is already functional in Indian judiciary?
Who would like to answer that question? Anybody? Yes, Mr. Joseph.
In my understanding, it is not there in any of the high courts.
I'll tell you. I'll answer it. faster 2.0, fast and secure transmission of electronic
Is
record, which
mounted
is,
on blockchain.
yeah, and DLT also. Uh, I can tell how it functions if the time permits.
Yes, yes, please.
Sir, this works, the faster system works on a closed domain. All the jailers, superintendent jail, all the trial courts, all the high courts are given user ID and password to access the Supreme Court database. Whenever an order is passed and it is to be transmitted to a concerned authority, it is transmitted through a closed domain, and whatever is transmitted remains on the server of both the Supreme Court as well as the user. So it has created a blockchain between the server of the user and the server of the Supreme Court.
That
And
that
it,
will hold true for a QR code also.
yes, yes, but you cannot change
No, if
whatever
I
is sent,
scan
whatever,
scan a judgment, there is a QR code on any high court's
yes,
judgment.
but QR code can be tempered, the judgment can be tempered, but what document was sent to a particular user and what document remains on the server of the Supreme Court, that is blockchained. So it is permissioned blockchain. User can access the database of Supreme Court to verify whether it contains the same QR code, it contains the same content or not. So this is faster 2.0.
So what brother is only wanting to answer is that this is a system which is existing already.
Yes, sir.
That's what he's saying. That basically when Supreme Court orders are being passed, they come to the High Court, there is a Supreme Court cell. So therefore it verifies all that and then further passes on. So this is already a system which we have, which is in place. That's what the answer seems to be.
I request that E-committee may take up this matter because the faster 2.0 is scalable. The high courts need not to reinvent the wheel. We can go to the faster 2.0 and same can be deployed across the high
Integrate
courts.
the district judiciary with the high court.
District judiciary or jails.
Jails also.
If the high court passes an order releasing any accused,
Our orders are transmitted through faster. Our orders are transmitted through faster.
so some of the high courts are not doing
High court, we are transmitting our orders through.
to the jail. Maybe some high courts are not doing
Our registered information technology
too faster.
can
They
assist
have
us.
developed. They have
It
developed
is
their
there
own
in Kerala.
system.
Kerala, it is being done.
All high courts.
It's being done in a lot of high courts. Few high courts are not doing it.
We have the faster system, but whether it's blockchain or not, I don't know.
Faster 2.0 is blockchain.
The our registered IT is there. Yes, sir.
The faster 2.2 itself, the architecture itself is within the blockchain technology logic.
That is what just.
It has to be extended for the district judiciary as well, because any session judge, it passes any order, it should also go to the jails or the.
Why don't you use the mic? Mic? Yes. Yes. Please identify yourself.
I'm registered Subrosham Ghoshal, registered RST, Calcutta High Court.
Yes, please. Yes.
So the faster technology itself is premised on this blockchain technology. But what we need to do is, if any session judge or the sessions court passes any order, this thing has to be passed to the correctional home. That thing we don't have right now.
All right. All right. Thank you. Thank you. Is there any other question from anybody? Mr. Bhatti, you have been looking at the panelists since long. Do you have any question to shoot?
I think it was a wonderful session, sir. But the question is that the techniques which we are now evolving or trying to introduce in terms of securing the trust of the common man, each technique will be important. But one example that I'll give is that blockchain, we understood blockchain first time when we were understanding cryptocurrency. And that has really impacted the economy, and everybody has thought that how it is functioning. And US and India both trying to regulate it, many other countries trying to regulate it, have not been able to regulate it. So that is a assurance that it will have a trust level if introduced. That's all.
Thank you. Anybody else would like to take? We have just 2-3 minutes more.
I'd just like to add here, in the light of the wonderful, ambitious presentations of the chair and co-chair, the first step is introduce a verified, tamper-proof blockchain within the judiciary first. because to bring in matters like Order 21, Rule 97 onwards, where third party interest and the criminal side, the access to the police records and other things, you need a well developed blockchain at the police level, at the land level, on which the judicial blockchain will depend.
That's
So
right.
I would first suggest let us have our own judicial blockchain in baby steps, and then we can cover the roadmap, expecting blockchains developed in other segments.
Thank you. Thank you. Anything?
Just to add, Susie told, the discussion now would all come around and center, like Brother Sen says, that backward villages and land records not updated. The moderator has said to strengthen the systems. The Advocate General also told us an expensive proposition which the state has to step in. Brother Basak says that we need experts in the system to put it together. CBC says that there has to be a tamper-proof system. So the end discussion, if we all say that the system will not only have to be created by the judiciary, but also by the state, and has to run seamlessly. And then they have to be experts at all levels. It's a very expensive proposition also. But all the factors and the players will have to move together. I think that is how we can all now sum it up.
So just on the expense part of it, it is expensive. Today, a flyover costs 1,500, 2,000 crores. It is as simple as that. One flyover from point A to B of 1 kilometer costs 2,000 crores. Should not the state be spending money on this since the AG is there?
Infrastructure is always an expensive proposition, but a necessary proposition.
But it inures to the benefit of the state also.
Everyone.
Their time, their efforts, their money, everything is saved.
So just two quick thoughts.
Future litigation also in land cases.
I can
Ease
give
of
an
business.
example of NDPS compliance with Section 40 NDPS, right? Starting from the seizure right up to trial. Now, if that custody is blockchain and every step taken by the police personnel who is on receipt of the information leaving that police station, if that is blockchain, so much of our bail applications, sampling, everything, so much of our bail applications, there'll be a huge reduction. Maybe the litigation will also reduce. If from inception this process is not correct in accordance with the NDPS, there's no criminal case. Now what are we dealing with? Why a bail? Why not a 482 straight away?
So
Yes, one last and then
two quick points.
draw curtains.
One is it's not tamper proof, it's tamper evident. Whenever there's tampering, it becomes evident in a blockchain. That's one. The second is the other question which Justice Basak posed. I don't think it has been answered. If somebody can come up with a concrete answer, it will be useful. That is, if normally changing what is uploaded becomes very difficult. So if the judgment or the amendment to the decree, how do you address that if it is in a blockchain?
Now most probably the chameleon hash, they have come with some modification by the administrator and others who have the power. They can do some modification with the hash, which is called with the key. It is the chameleon hash.
It's difficult but not impossible.
All right, ladies and gentlemen, it's 11 and our time is exhausted. We have been talking about time stamping. Let the time stamping of this session be impeccable by closing at 11. We have had really very, very absorbing session. I'm sure there are more questions in your minds, but unfortunately we are totally out of time. Very, very insightful discussions we had, which commenced by the very exhaustive and extensive presentations by the chair and co-chair. At the end of the day, what I would like to believe is that while it is important for the judiciary, the judges to have some idea about how the technology works, we perhaps need not go very deep into technology. What is blockchain, how data migrates from here and there? These are not subjects for our in-depth understanding. We don't need to deep dive in these things. What we should sit and talk more about is what is that we want from technology to happen in our system, which is going to make our life much easier as judges and judicial officers. I don't know if I have missed out. I have not come across a single topic in a technology conference where this is discussed. We go very deep into what is blockchain, what is permission blockchain. Most of our judges are not aware of what is this. Even those who are aware, there are gaps. You see, with all respect to people who have knowledge on this technology, there are serious gaps and which are bound to happen because we are not technological experts. This technology changes by the week, not even by the month. So we have the money, we have the people to provide technology. I don't think we need to go very deep into it. We must sit down, discuss, and figure out a roadmap as to what do we want from technology and what are we prepared to accept. And for doing that, technology, digitalization is all about interplay of data. Till the judiciary has a national data usage policy for judiciary, my view is we cannot even think of AI and blockchain. With these few words and with the permission of the chair and the co-chair, may we declare that this session has come to the end.
We must thank
I want to thank Honorable Justice Mushtaq, the Chief Justice is not here, Chief Justice of Kerala High Court, the entire registry of, Sikkim High Court, for inviting me, extending all the hospitality, and giving me this opportunity to be a part of this session. It's been a wonderful learning experience for me. Thank you so much.
Thank you, Lordships and distinguished guests, for the engaging and informative session. We will now have a 15-minute tea break. The organizers are requested to escort all the distinguished guests for tea break. Thank you.
Evolving and responding to the changing societal needs and challenges. Wisdom, in its common parlance, is a complex, acquired personality trait that integrates cognitive understanding of life, reflective self examination, and compassion with empathy. A wise person's stable personality rests on three essential pillars: embracing uncertainty, intellectual humility to acknowledge that they don't know everything and can't control everything, perspective taking, the most important, understanding multiple viewpoints and practicing genuine empathy, emotional balance, composure, and stability when faced by difficult circumstances. Judicial wisdom, according to me, is thus distinct from intelligence. It is not merely intellectual ability, but the deliberate application of knowledge of legal principles to impart justice. There are risks to judicial independence, and when I'm saying so, I may put a caveat on it that I'm not uh, criticizing integration of AI. These thought process are for opening discussion to for opening discussion to the house. So according to me, AI comes with many risks when when the question is about judicial decision making. A major one is of AI's influence on us due to our complacency. Everyone worries about AI giving wrong answers. But have you ever thought, according to me, the bigger risk is when AI consistently meet our expectations. we slowly stop questioning and double checking it. Independent judicial thoughts quietly begins to erode. As principle, a judge's independence is not merely freedom from external pressure. It means deciding by one's own conscience, grounded in legal and constitutional principles, free from one's own prejudices and biases, allowing AI to influence that reasoning, however subtly, is against judicial independence itself. Today we are exploring where can AI tools assist first. As per my understanding, AI is more suited first for non-adjudicatory functions, processes characterized by three core features: rule-based, repetitive, high in volume. AI tools can assist in registry functions involving manual handling, such as e-filing, automated scrutiny, and case registration, thereby enforcing uniform standards, flagging deficiencies early, and enabling timely correction, drastically cutting filing delays. It can also identify case flow bottlenecks, cluster similar cases for efficient listing, and generate prioritization dashboards for court administration. The natural starting point is integration of AI, according to my little understanding, is with the e-filing module and case management software. AI thus can serve as an assistive, augmentative tool for the judiciary. Its integration requires careful oversight and structured deliberations among the judges in charge of judicial institutions. And I think that is precisely why we are here. Deliberations among multiple perspectives is the first step in adopting any new system. The first step is always a decisive one. Taking this first step, the Gujarat High Court adopted the policy on the use of AI in judicial and court administration on 4th of April 2026. Not with an approach to to prohibit or ban AI, but as a principled recognition of the need to evolve with changing times. The objective is to regulate, to prevent any such situation that may erode public trust or render the decision-making process vulnerable. The policy is a caution against the risk of gradual over-reliance on AI and of unintended bias in decision-making, while adopting and integrating AI in our judicial institutions. We understand that this is only a start in a very, very guarded way, balancing skepticism with openness. Now, this slide gives you the salient feature of AI policy of Gujarat High Court in Judicial Administration. We have also created a QR code whereby you can, if you want to see our policy, you can use this AI code, QR code for downloading the policy. That is very, 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 very basic. And what we can do today in this system, how we can adopt AI. With these opening remarks on my personal view on the adoption or integration of AI into judicial system, I'm opening the floor and giving to the floor to Justice Anup Chitkara, and over to you, Mr. Chitkara. So again, with the reminder that this session is going to be very, very interactive.
Thank you.
Thank you.
Thank you, Honorable Miss Justice Sunita Agarwal. So Justice laid down on following, she emphasized on following things: constitutional standards. Everything should be within the constitutional standards. Then human conscience, which misses in AI, reasonable person of ordinary prudence must understand. Then humility and empathy is something which AI is not able to match as of now. Judicial wisdom is distinct from intelligence, and she has also stressed for regulating AI. So I feel so tiny and humbled in the presence of such great and eminent jurists. Justice M. Sundar, most likely he would be the first judge who will supervise a cyborg in the coming days. We hope so. Justice Pushpinder Singh Bhati, Dr. Justice Pushpinder Singh Bhati, Justice Nikhil Kuriel, they're all, I was fortunate to have so many sessions with all of them. They are great, eminent jurists. You can put as difficult questions as you want. And Justice Michael is also very keen, enthusiastic of technology. So first question I will put to Justice Kuriel. Justice Kuriel, how can courts adopt AI incrementally, starting from low risk, non-adjudicative functions before moving to higher risk applications? So we are emphasizing the word on incrementally, slowly. We don't want to jump into straight away. What are your takes on that, sir?
Thank you, Chitkara sir, distinguished chair and co-chair, and distinguished panelists. First, though Justice Mushtaq is not here, but a very big thanks to Justice Mushtaq, Chief Justice Mushtaq, for conceptualizing this conference and for giving me this opportunity. Now, I'll answer this question from the perspective of the policy which we have framed in Gujarat High Court, the discussion which we had while framing this policy. So we believe that initial AI deployment must pass a three-part test. The function must be rule-based, repetitive, and high volume. Filing scrutiny, scheduling, and least optimization would be the natural first candidates, more particularly because these are governed by clear rules occurring daily and easily correctable if something goes wrong. Now, why rule-based, why repetitive, and why high volume? We believe that if it is rule-based, then we find we have a clearly defined procedural requirement which would eliminate ambiguity, which would allow the AI system to operate within precise boundaries and without any interpretive discretion with the AI. Any errors which may arise are easier to identify and correct because they occur in a known framework. We say about repetitive because it will follow this. If the AI follows the same pattern, then it will allow the AI to deliver consistent results at a scale, and this would reduce human effort and would improve efficiency and lower operational costs. With high volume efficiency, we believe that where in areas where we have high workloads, introduction of AI would result in immediate relief and it would get things which are in large volumes done quickly and effectively and accurately. And this would reduce bottlenecks and would improve overall system responsiveness by managing the scale more effectively. Now, we looked at it from the perspective of bifurcating the registry functions into two parts. Incrementally, as the moderator was saying, we believe that incrementally first would be that it should be split. There will be no AI involved in non-registry functions. That is the first part. Even in registry functions, we split it up into two parts. We have deliberately mentioned that AI would not be involved in any function which will which has confidentiality aspect in it. So the data involving infrastructure budgets, which will have judicial officers' records, and other confidential institutional matters are strictly excluded. They are all within the human domain. And for AI, we believe that non-confidential administrative functions such as pendency analysis, filing trends, and compliance reporting, where AI can synthesize data and generate reports swiftly and accurately, could be the first starting point. We believe that AI should function as the diligent first reader where it can scan filings for defects, verify procedural compliance, and organize documents before any human officer examines them. The triage model ensures that human attention is directed precisely where it matters most, which reduces delays at the intake stage itself. From the perspective of Gujarat High Court, the where and the how analysis leads to a clear conclusion that AI is best introduced at the scrutiny stage, functioning as the first eye. Now, filing scrutiny ensures procedural compliance before admission. It is structured, rule based, and repetitive, making it well suited for AI introduction. AI being introduced here would reduce burden on the registry staff and speed up case admission since these tasks rely on predefined rules rather than judicial discretion. Now, AI also can be used in assistance for checking formatting compliance, for identifying missing documents in the filing, and also for detecting duplicate or repetitive filings. A practical illustration would be that in an e-filing system, AI can instantly flag issues like missing page numbers or incomplete annexures, allowing advocates to correct them and send it back within a few seconds instead of days. Now, while incrementally adopting AI, we also believe that there has to be a human in the loop. We believe that AI system should never function independently, especially in judicial process. Judicial process, I don't mean the core judicial functions, I mean with processes attached with the judiciary. Human oversight would be essential at every stage to ensure that decisions remain fair, context sensitive, and accountable. While we believe that AI can process information quickly and flag issues, it doesn't possess judgment, discretion, or understanding of unique circumstances. Keeping a human in the loop ensures that AI remains a support tool rather than a decision maker, and that any errors or anomalies are caught before they affect outcomes. We also believe that introduction of AI, even incrementally, should be with the following safeguards: that every AI output must pass through a human checkpoint before it has any operational significance. There must be auditability because there must be a traceable record of what the system has suggested and what the human has decided. And as Honorable the Chief Justice was saying, the courts must guard against automation complacency. Back to you, sir.
Thank you, Justice Nikhil. Now I would request Justice Michael, if you want to say.
Just to add one thing what Nikhil has said, just an addition. What when we were framing this policy, we discussed and bifurcated registry into two areas with lot of consciousness about three principles, that is, it should be rule based, it should be repetitive and high volume. So registry, according to our understanding in any high court, functions in two areas. So one is where public is involved, and another is where registry discharge administrative functions, administration of high court and district court. So this is open to house, and we can be enlightened by if house need to say anything. What our understanding was that when registry is discharging administrative function of the high court and district court, these three principles are not there. They are not, they may be rule based, but there are peculiar situations. Then they are not, may not be repetitive, and they high volume is not a question there. And then there are risk involved that we are putting, like I think someone was discussing that what data we are ready to give to AI. So we don't, like we thought that we don't think that we need to give that data to AI, which is our administrative data. So this is just my addition.
Now I will request Justice Michael Zotham Kumar to tell the audience that should AI be trusted to flag defects in filing the pleadings, and what procedural safeguards are necessary to prevent wrongful rejection of pleadings by an AI-based application.
Distinguished Chair, the co-chair, the Chief Justice of Gujarat and Manipur, the Chief Justice of Allahabad and Himachal Pradesh, my co-panelists, here, brothers, distinguished participants. The first question, I believe, that was put to my brother has basically answered half of it, I think, half the question you have placed before me. Now, AI be, should there be filing in the registry with the use of AI? Well, as he said, because it is rule-based, repetitive, and high volume, well, it is being done everywhere. Now, the issue that you have said is whether they should flag defects in filing. Well, because it is speedier and it helps time saving. AIs, they should they should flag the defects. However, when there is any adverse action to be followed by rejection, I think there should be, like my brother had said, there should be a human in the loop intervention. And that could, but I think this human in the loop intervention should only occur when there is a flagging of the filing by the AI. Otherwise, you're going to double the time. One of the most serious questions about using AI in the judiciary is often called the black box uh, problem. The system must be transparent and explainable, and I believe consistent with the principles of state versus Lobis, the Wisconsin Supreme Court judgment 2016, which emphasizes that automated tools cannot operate without accountability or scrutiny as of now. The litigant also must have an immediate right to contest the defect before a registrar or court with time-bound disposal to ensure that limitation is not prejudiced by technical errors.
Justice Jotham Kumar, how can AI be used for case management, legal research, or decision support within the framework of Indian Constitution?
Mm, well, legal research, AI can be used for case management and legal research for subject to systematic bias testing before deployment. And such testing must be against databases which are free from human bias due to maybe religion, caste, or race, or some other uh, reason. Deployment of AI in use for case management and legal research should not be operation independently so that it can improve efficiency by reducing time spent on repetitive and data intensive tasks. When it comes to implementation of AI in decision support, it must be noted that the constitutional framework, the adjudication of rights, liberty, and liability must remain human. As AI systems are not equipped as on date to perform normative reasoning evaluation of evidence, like we notice in the district courts, when there is the evidence is taken, there's a lot of nuances that has to be taken care of by the court, like the demeanor of the witness, uh, the, 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 the accent of the, the subject therein. So the application of AI in decision support must be strictly limited to roles that are assistive and rather than being final or decisive. As we know, hallucination, whereby um, hallucinations are fabricated content, which could be due to limited or biased um, uh, training data being provided into the system. So I think and I think in the earlier session that already spoken of, there should be periodic training given to the court staff and even to the judges, which in fact more to the judges maybe. So
Yes. Thank you, Justice Michael Jothan Kumar. Now, Justice Nikhil, can I ask you that should AI be used for predictive case analytics, such as estimating the likely duration of a proceeding or the probability of certain outcomes?
Sir, now while we are discussing where to introduce and how to introduce AI, I believe that this part, permitting AI to decide or to analyze and tell the duration of a proceeding, and more importantly, the permitting an AI to predict the probability of outcomes should not be permitted, not now, and should never be permitted. And I believe that at some point of time, there should be a statutory bar which should ensure that no AI should be permitted to display or come to such an outcome. And the objection is not merely technical, the objection is philosophical. Law, as we all know, is not a calculation. A court does not operate like a weather station issuing probability forecasts. Justice is dispensed through reason, evidence, argument, and discretion, and not through statistical inference drawn from historical patterns. We all know that a seemingly innocuous prediction of when a case will conclude is fraught with difficulty. Courts do not and simply do not and cannot possibly know what lies around the corner. A key witness turning hostile, a transfer of the matter, an amendment to the pleadings, or a change in the bench. And these are not outliers, they are everyday reality of litigation. To feed litigants a predicted end date is to offer false comfort dressed as data. The law, I believe, deals in certainties of process, not certainties of outcome, and any tool that blurs that distinction does disservice to both. Now, there is also an inherent risk of misuse. Predictive analytics, if made available in any form, create serious opportunities for misuse, and the courts must confront them very squarely. Like we all know about forum shopping and bench hunting, and if we permit the AI tool to predict the likely outcome of a case based on historical data, then they can by extension be used to identify which bench, which judge, or which court is statistically more likely to rule in a particular litigant's favor. This is bench hunting in a sophisticated, data-driven form, and a litigant armed with such a tool could strategically time filings, seek transfers, or engineer adjournments to secure a more favorable forum. This strikes at the very root of judicial impartiality. Now, unethical lawyers, unscrupulous practitioners with access to such predictive tools could use outcome probability data to pressure vulnerable clients by overstating the strength or weakness of a case based on algorithmic outputs rather than honest legal assessment. And if parties enter a courtroom armed with an AI generated probability of success or failure, then the incentive to genuinely engage with the opposing party diminishes. Litigation ceases to be a search for truth and becomes a contest of competing algorithms. The result is a subtle but corrosive erosion of the open minded adversarial process. Now, AI predicting the probability of success or failure in individual cases or offering predictive analysis of evidence must also be firmly discouraged. And such tools, I believe, risk creating a self-fulfilling prophecy where the algorithm's prediction influences the conduct of parties, counsel, and potentially even courts, consciously or otherwise. And it reduces the unique facts and human circumstances of every dispute to data points, stripping litigation of the contextual sensitivity that is the hallmark of justice. I also believe that if we are to permit predictive analytics to be deployed, then it could be at a very, very nascent or a basic level, and that should be non-negotiable. That is, there should be full and complete disclosure to all litigants regarding the nature of the tool, its purpose, its data sources, and the limitations the AI has. A clear and a prominent disclaimer that all outputs are non-binding, purely indicative, and in no way reflective of judicial opinion or likely judicial conduct, and a strict separation from all adjudicatory processes. Now, sir, we all know that even if we have a 1% change in the facts, there is a likelihood of the outcome changing. So allowing the AI to predict, and I don't suppose even if with 100% accuracy, it will be able to touch the human element of every case. So, in my understanding, it should be no, not today, never. Thank you.
Thank you, Justice Nikhil. Now,
To this question was, I suppose, it has two parts. One is estimating the likely duration of a proceeding. Another is probability, is the estimating the probability of certain outcomes. So this question is to the House, and anybody can answer. The first part, according to my understanding, the estimating the likely duration of proceeding. Can it be used as part of the case management, like in a criminal case, after the charges are framed and calendar is supposed to be prepared by the judge holding the who is the presiding judge, and we have not come across a single instance where they are doing it. In our judicial officers conference, we have asked this question also. Have you ever prepared calendar for your case calendar, which is actually it is incorporated and conceived in CRPC itself. So no one does this. So this estimating the likely duration of a proceeding, is it possible for the judicial officer, a judge, presiding judge, after the charges are framed, he prepares the calendar with the assistance of the public prosecutor and then prepares the estimated case duration by putting information on AI. And that AI definitely has to be developed by the court only. No private AI can be used according to me. So this is the question to House. This has just come to my mind and I'm opening it to the House.
As far as time estimation is concerned, my experience speaks that a judge knows how much time is to be taken in this case with the assistance of the PP. AI tools can definitely help it. And there is no embargo as such. Right now, I was in the startups, I was talking to a young boy who has some AI tools developed for court management. So I asked him a question: who may have access to our data?
Correct. That
So
is the issue.
he said that we have an open AI links and all that. So we know what's going on in California court with open AI in the legal battle going on. So then he says that initially we will give you in writing, we will guarantee you that everything will be with you only. So this can definitely be a part of it. But I don't know how much time it will take, because within 2 minutes, a judge could say this session trial would take 3 hours. Within 2 minutes, experienced session judge, a magistrate, he knows 25 witnesses, he knows it's a recovery case. There would be 4 witnesses. How many witnesses? 4 witnesses. He knows. 10 minutes. Thank you.
This aspect has been dealt by me in NCMS report, which prepared with Justice CM Joshi and with the support of Mr. John Verghese. So we said it is possible to fix a timeline based on algorithm, taking account of the complexity of the cases, total number of pendency of the cases, number of witnesses. So algorithm itself fix the timeline. So the one aspect we always keep in mind that currently the unit system works. It put a lot of stress on the district judiciary. We never take into account of the total pendency of the cases, caseload of the court, or number of witnesses. These aspects, if of course we overlook, we only look at disposal of the case based on the date of its registration. So algorithm can identify and fix a timeline, taking out all these aspects. It's as simple as that.
So question of data would not be there at that stage.
No, it will be there.
It will
Each
be there.
proceedings, because it is, of course, that is a one aspect of digitization. Once digitization happens fully, the algorithm can work its own, determining timeline.
Anyone to add?
I'd like to add to it. What happens is that there are too many variables for the judicial officer to kind of have a grip on the timeline.
Correct.
His intentions may be well kind of intended, let's put it that way. He is striving to dispose it off because of his point system. He wants an early disposal, but he needs to be assisted. And there comes the function of the public prosecutor in getting those witnesses on that dock, on that scheduled dates. Experience is otherwise. Experience is otherwise, and that's why whenever when I interact with the judicial officers on this point, they say we are open to put in three consecutive dates or 5 consecutive dates for one particular matter. But unfortunately, we find that the crucial witness who is crucial to that chain of evidence is not turning up. So my 5 days is gone, and I am looking at pendency maybe more than thousands, maybe in more than 5,000. So when I'm fixing those time limit for a 5-day period, I'm consuming, then I have nothing to do, nothing else to do. I have not fixed any other matters. Then I'm wasting judicial time. Then where do I stand? So that's a very practical problem.
So that's the preparation of board, and for a judge, presiding judge in a civil court or a criminal court, they have a fixed board for a certain period. If they are posted in one
That is
station,
also
they
there.
have 3 years, they have
Right.
fixed number of cases. So we have one chief judicial magistrate here. I think you may enlighten us on this.
Thank you, ma'am, for the opportunity. And let me also thank Honorable Justice Mohammad Mushtaq, sir, and the entire Sikkim judiciary for the wonderful program that has been collaborated here. From our experience, the position is that in the district judiciary, there are local variants. Like what happens is that the probability of a particular witness coming or a accused comes depends upon a lot of local factors also. For example, in my district, Pathanamthitta, during Shabarimala season,
That stage comes only after you prepare the calendar. So we are discussing only about the
exactly, ma'am.
stage. Like you have 10 cases, a new case comes in your court. You take cognizance of it, prepare the charges. You call upon the accused and then settle the charges.
Lordship.
After that stage, I think, I suppose, CRPC says that you prepare a calendar as to how much time this case will take and how many witness, depending upon the number of witnesses. So whether at that stage AI can help.
Lordship, in Kerala, in most of the courts, the average pendency is 17 to 18,000 cases. 17 to 18,000 cases means you can't afford to have a proper calendar, as your Lordship has rightly pointed out. AI can help you in making a calendar. AI can help you in managing the aspects which which you cannot.
Share that calendar with the public prosecutor, and you you prepare that at that stage that this is your calendar for this case. Is it possible?
It is possible, ma'am, because AI can, as sir rightly pointed out, the algorithm can find out the factors where whether there's an age case, whether there's a case which involves n number of witnesses, and that which dates this probable to fix this witness examination. And once this is called intelligent scheduling. Once this intelligent scheduling is there, the human judge can overlap. He can use his discretion to change it, but there will be a band given to him so that within this band, base within which he can change it.
Thank you. I think we can move on to the next question.
Justice Bhati, how to strike a balance between efficiency induced by AI and the confidentiality of restrictive and sensitive pleadings, evidence, and awareness of the judgment?
Thank you, sir. Thank you, Mushtaq Saab. Well-known, renowned NJ man, strong man. Today, our Chief Justice here in Sikkim. He has brought us all alive. Our chair, co-chairs, Chief Justices, friends, fellows, brothers, sisters, younger brothers, younger sisters, students. Like earlier session, it was said that blockchain technology to be introduced or not to be introduced, something like a safeguard, a trust module, some kind of safety measures, some kind of, it was all something which we all know should be made available as far as possible. This house is extremely, the next topic which we are now dealing with is very important, because when I was, sir, taking the uh, interviews in Rajasthan Judicial Services, I was asking each of the aspirants that whether you will use AI to write your judgments or not. And I was amazed to see that 90% of the aspirants said that we will use AI. And out of them, today the academy is having a batch of trainees, which is interesting part is now 220 trainees are there, and 90% of them in aspiration they said this we'll use. Today in training in academy, I asked the same people who have come through the same prism. I asked them, will you use AI? All of them said no. So I said now they are trained to be judges. Then I asked them, are you otherwise using AI? Yes, otherwise we use AI every day, sir. So now what I was asking the chair in the tea time was, the question is that how do we make it? How far do we go? That is why judiciary has to see whether we have to remain analytical, whether we have to be predictive, whether how far we have to go. That is the important question, because predictive, generative, analytical I think is no problem. Analytical is no zone where we need to worry about, because I see all of you must have seen when we joined the profession in 90s, there were big registers of for research, and there were big digests in each office, A, B, C, D. We used to, like dictionary, we used to see. Slowly, it all changed into softwares. And as we move from softwares,
We used to maintain registers.
and we used to run behind those
Index
registers.
wise.
Ma'am, you must be in the generation where you made the registers. We were running
Yes,
behind the registers.
ABCD.
We would go behind Arun Mansali sir and ask him, what is your register today, sir? Please tell me something on this case. So he will smile and sometimes give, sometimes he will say, okay, I'll tell you, I'll guide, but always guiding factor. So that was the element of research or maybe analysis. Now today it has moved on to softwares, and then software also there was a problem that anybody who would be having a skill to prompt, the right kind of prompt was required. If the prompt was not proper, the research was improper. Now we have refined it. Now even the prompt can be done by the AI. We only give some points to them. And once we give those some points, then we understand that how it is going to happen. So this is the change which is happening. Other days when we were attending CLIA conference, then in that conference, that London Times editor, law editor, he said that 2 years ago I told him to write a law article as me, who is one of the world's famous law editor. He said, write like me. So he wrote, the AI wrote. He said, I was very satisfied because nothing compared to me. He is nothing compared to me. And then he said, after a few months, I again gave the same prompt, write like me, and I was amazed. It wrote better than me in the same style, in a much more analytical way. So that's why it is changing. In that same CLIA conference, which was there in Delhi, there were a number of countries, which if I rightly recollect, Nigeria being one of them, they have already introduced us for complete judgment writing. And the best part was that the Chief Justice of the Nigerian Supreme Court, he said that all this judgment writing technology, everything in AI we have got from India only. And, and he said that India has only given to us, and your firms we have given contract, and therefore we are using judgment right in everything, including conclusion. He was candid enough. He said, including anybody from CLIA, that day, a lot of us were there. They said, oh, we are writing. Other countries also which said that we are writing judgment. That means not analytical, not predictive, but generative. So how far we have to go, that is the important question. And I must confess that hearing those international chief justices and justices was eye-opening for us who were nominated from High Court, because we are still at a nascent stage. Gujarat, Kerala and Manipur have given us some policy thinking. I think time has come when the judiciary itself, when we get together in this kind of conclave, we have to now probably think how far we have to go. See, as far as judgments, they are public property. Every judgment is free of cost available. Today we have a neutral citation. Today it is available to the public. So if it is used by AI, whether there should not be any problem because it is a public document. Then slowly the problem comes in when we start giving them other information which we may not be, because today there are three limbs. I think just pouring out my ideas. There are three limbs which are in contradiction to each other. And since each of one are legal expert minds, one is this country one day awoke to right to information. Everybody says information should be transparent, should be going on, RTI Act, this, that. Then we had Puttu Swami. They said, no, privacy. I had 10 interns who were interning with me. I said, why do you need right to, I said, we were discussing this, the interception by the government in the end-to-end encryption. So I said, if law and order, I asked a question, if law and order situation demands, can this end-to-end encryption of WhatsApp, etc., should be broken? So they said, yes, sir, if law and order is there, then it should be broken. Then I said, would you, any one of you like to pass on your WhatsApp to me to see? Oh, no, sir, we will not give. So end-to-end encryption is there, and it was on the lighter side, but all of them said that we'll not share. None of them wanted to share their WhatsApp messages or this thing. Not that I would have read them, but this is the generation, which is generational change which is happening, and judiciary has to fast adopt it. And believe me, ma'am, AI is standing out, waiting to storm in. It will storm in. Only thing which we can do is that we can regulate it. Maybe we can protect some data. Maybe we can use it in a more intelligent way. Maybe we can use the storm to produce, like a windmill, we can produce energy out of it. So it is, because it is coming. Why it is storming is because the pendency is the challenge that every person who's associated with law will have to face. Sir was saying something, adding something.
No, even before the AI, there was a judge in Kerala who collects draft judgment from both sides and applies mine and choose one. So it is happening now. You ask AI writes the judgment, you apply your mind is best good or not and decide.
So judiciary has to achieve where it can sleep in storm. So achieving that target, sleeping in the storm of AI, we need to do a lot.
We have to make good beds so that we can sleep, relax rather than relax peacefully.
Sleeping in the storm is our dream.
Chair is right.
Can we move forward?
Yes.
Yes.
Justice Zothan Kumar, is it safe to rely on AI for transcription and preliminary analysis of witness testimony, and what human verification protocols must accompany such use? Yes. Is it safe to rely on AI for transcription and preliminary analysis of witness testimony, and what human verification protocols must accompany such use?
I think it can be safely used for transcription and analysis of testing or witness testimony. However, it has to only be used as an assistive drafting tool. It cannot be an authoritative record because there are many nuances, like I said earlier. The way, the tone of the witness, the demeanor of the witness, there's so many things. Hesitation can be there, which AI, as on date, may not be able to recognize. But like I said, for now, in the future, what happens, that's a different issue. Because if you see your phone sometimes, when you go to some web, they'll ask you, are you human or a robot? Are you a robot? Sorry, not human. Are you a robot? And that's a robot asking me. I have got to justify myself to a robot. Another thing, I think maybe a dual verification protocol is required. Right now, trained court staff and the judge in question, who should personally review that, and there should be periodical reviews of this. I think I'll stop for now. Time is going on.
Thank you, Justice Michael. Now, can I ask to chair Justice M. Sundar? He is one of a judge who claims to be deep fake, but actually is deep mind. So, Justice Sundar, to what extent can AI assist in judicial decision making? Most difficult question to you.
Thank you, Mr. Chitkara. Now, moving on from administration to judicial decision making is very appropriate for the occasion. Being the last session, I think it is like moving from the hospitality to the weather here. Warm hospitality in cold and cloudy weather. Thank you, Justice Mushtaq and your team, Sikkim High Court. I think the Advocate General is here. Thank you, State of Sikkim, and the Judicial Academy, which is an adjunct of the Sikkim High Court. Now, coming to judicial decision making, if the question is, can AI be used in judicial decision making? Question mark. The answer can be binary. I will say unhesitatingly, without fear of contradiction, no. Comma, as of today. No difficulty about it. But the question is framed as a little tricky. That's the reason why he said it's the most difficult question. And that is predicated on the last sub-theme, which again is very, very intelligently put. Because the last sub-theme says, to what extent AI can be used in the judging process. One, to what extent, and two is used in the judging process, not in judicial decision making. There lies the catch, and probably it is a question which contains the answer. It's a leading question. Probably it emanated. I can understand where it emanated, where it emanated from. No, I will not turn hostile. I will so therefore I will not subject myself to cross-examination, though I'm open to questions. Now coming to the point, very, very simple. To what extent you can use it in judicial judging process? I would put it like this. In the non-decisive functions of decision making. If you ask me what are the non-decisive functions of judging process, I would say for instance, transcription, or maybe legal research, maybe document summarization. These would be the non-decisive functions of judgment or judging process. To that extent, probably you can think of AI. Now, the Gujarat High Court has rolled out a policy about Honorable Chair articulated, Brother Justice Nikhil Khairiyal also articulated. If you see, the grand norm or the bedrock is rule-based, repetitive, high volume. This is the grand norm. The reason is this. What is this AI? We talk so much about AI. In a minute, I will tell you, if some of us think that AI, now I'll just throw it open to the house. How old is this AI? How old is this AI? 10 years? 5 years? 1960s? Any other answer?
50s, 60s. 80. 50s? 80.
Much old.
Older? All right. If somebody asks who is the father of AI, one may say John McCarthy, 1956. I beg to disagree. I dissent. He coined the term artificial intelligence in 1956. But if you ask me, who would you credit to be the father of AI? I will tell you, it is Alan Turing, British mathematician, who invented what is known as the imitation test way back in 1939 to 1945 in the Second World War.
At the age of 26.
Yes, at the age of 26. He died very early. Many good things are short-lived. There's also exigency of time. The point is, imitation test was used to decode German codes. And that would be, the imitation test is probably the first AI app, 1939 to 1945. Therefore, the AI surge now is more because of the computational skill. Now, in very, very simple terms, when it comes to judicial decision making, I'll just take 2-3 minutes on this. If we get a clear idea of what this AI is, we will have no doubt in our mind as to whether to use it, and if yes, to what extent, and 3, how. AI is nothing but another app. You have a huge data, It's a mine. It's a data mine. And then you have algorithms. Algorithm is a very technical term, but algorithm is nothing but pre-programmed set of instructions. And it works on LLM, large language model, meaning you can put it in the form of a question, not just search words. Therefore, you get a feeling that you are talking to another human agency. It is not. Now, once you put a prompt, these algorithms pound the data and it looks for patterns. It doesn't think. It has no cognition. It only looks for patterns. That is the reason why, if you see in the Gujarat policy, repetitive, the second point, repetitive as it gets, that's one. And if this is the case, you can probably consider but not rely. That's the basis. Now, whether AI has got cognition, what I did was I put this prompt to an AI app. Please see the answer. I'm not using the name of the app. The reason is they're all proprietary software. I'll just show you in a minute. The prompt is in purple. The conclusion is in blue. Prompt 1, write a note on whether AI has cognitive skills of human mind. After a long answer, it summarized it like this. The answer is, in summary, AI can replicate some cognitive functions through programming and data processing, but it does not truly think. Think within quotes or understand within quotes like human mind. Its abilities are limited to the scope of its training and algorithms without the depth or flexibility of human intelligence. That's prompt 2, please. We'll just have the prompt 2 also. The second one. Prompt 2. I said write a note comparing human mind and AI. The conclusion after a long, I've just put the conclusion alone. While AI can perform specific tasks more efficiently than humans, that's computational skill. Let's not have any synonym. I consider that to be a synonym to thinking. While AI can perform specific tasks more efficiently than humans, it lacks the emotional depth, intuition, and true understanding of the human mind. The two are fundamentally different. This is what, mind you, an AI talking to you. This is an answer from an AI. AI is a tool created by humans, not a replacement for human intelligence. And the third prompt, I'll stop with that. The third prompt. Write a note comparing human mind and artificial intelligence. Please see the conclusion. When AI is a powerful tool that enhances human capabilities, again, computational skills and speed, it cannot fully replicate the depth, emotion, and consciousness of the human mind. The best outcomes often arise when humans and AI work together, combining emotional intelligence with computational strength. This is the fundamental when it comes to using AI. The reason why I brought it up is, as judges, uh, none of us are technocrats. Maybe some of us may have a technical uh, degree, I don't know. But most of us, I would say, I won't say none of us, I stand corrected. Most of us are not technocrats. But we fall in three categories. One, those who are extremely tech savvy, those on the right, including Suraj and others, other younger members. And two, those who are averse to technology, the other side of the digital divide. Three, enthusiastic end users like me. But we are not technocrats. That is the reason why I brought this up with regard to. I will just conclude with, I will put it this way. When it is a question of whether AI can be used in judicial decision making or judging process, I would put in 4 caveats. The first one is, as of today, we have no codified legislation. All AI are proprietary software. We don't have a codified legislation. We need to have a codified legislation, which may probably say you have to tell the litigant that AI has been used, if used for which part and for what purpose, so that he can have an immediate defense or an opposition to put in, and then to make it clear where the human in the loop element is, all these aspects. That is why the Gujarat policy says rule based. One. Two is consider but don't rely. That's the Loomis, which Mr. Michael pointed out. That's the Loomis principle, where a recidivism tool was used for sentencing, and the Supreme Court of Wisconsin said, consider and rely are being used synonymously. Please don't do it. Consider, but don't rely. That is the second most important aspect. The third caveat I would put in is possible judicial stagnation. I will ask you, and probably a prompt, I will leave it to you. I asked myself and place it for the consideration of this house. Who will write the dissent? Dissent is future intelligence. Who will write the dissent? Judicial stagnation, if it's repetitive, may occur. Caveat number 4 I put in. The last caveat I would put in is cognition of human mind should not become a casualty. And to sum up the answer, when I say consider but don't rely, for instance, I'll give an illustration and conclude. For instance, one of the non-decisive functions of decision making would be transcription. Let's assume that you're using an AI tool for transcription. If somebody has to understand what the witness is saying, then the judge repeats or the person understands and then keys in. A lot of time is consumed. If it's transcription, the time is saved. But what you have to be careful is the human monitoring to ensure that there is no demeanor gap, what we call demeanor gap. The transcription cannot capture, or it cannot write the demeanor. The demeanor has to be written only by the human being. Therefore, it is the human mind which works with the AI, part machine, part man, meaning cyborg. When you talk about using AI, we should not get robotized. We should not become robots. But we can consider cyborg. What I did was, with the help of my Registrar General, I asked one of the AI, I have to give credit to him, how a cyborg judge would look. This is what it generated. This is, so that's what I would leave you with. And one last thought I would leave you with, one very, very last prompt, probably in the concluding remarks with the permission of the chair, we can consider that subject to the exigency of time. We talk much about data bias. There was a session with an IIT professor whose domain expertise is AI. When I said the data bias, he shot back. He said, why human minds don't have bias?
We have so many.
Can you say the human mind is free of bias? So what is our answer to this? If you say using AI is one of the impediments is data bias, does human mind does not have bias? I leave you with this prompt. We can proceed further, and probably in the concluding remark, we can.
Just to add, like once you were making different distinction between bias of human mind and data bias. So data bias, I suppose, is systematic. This is systemic. There the problem lies. Human mind, again, it can evaluate itself. It can evolve itself. You can always correct yourself. So that self-correction, which is there, Like we have biases, we have prejudices. We can't say no, and we can't say with this conviction that I have no kind of bias. But then, while making decision, we always need like a judicially trained mind. So you tend to self-correct yourself. There, the distinction lies, according to me.
So, one question for Justice Sundar.
Yes.
Now, these three prompts which you had put across, what if, what if the AI was lying? Because the concept of artificial, now we are in generative intelligence, generative AI, we are getting into the concept of artificial general intelligence, which is supposed to be 2047, preponed to 2039, then to 2030. Now, NVIDIA chairperson said general intelligence has already arrived. Of course, he said a CEO cannot be replaced. What if it is general intelligence which is already available?
We need to hurry up now because our time is over by now. We still have 3, 4 questions left with us.
With permission of chair. So thank you, Justice Sundar. It vindicates my stand that you are a deep mind. I'll now move on to Justice Bhati. In a short brief, should there be a declaration by the person utilizing AI in the judicial process? I'm using the word person, not an officer, including judge.
All of us who are judges here from any category, all of us are using Supreme Court judgments in our judgments. We put our judgments there. So when we put those judgments, are we doing anything wrong? The wisdom of the apex court we are using for our judgments to make it more strong, to give it strength of precedent law. Same thing is here also. What we do in Supreme Court judgment, we quote it. Honorable apex court said this in such and such. So similarly, the answer could be, and I try to explore it. Some of the countries are doing it, like Ireland, where they have a declarative format, where they say if in the judgment or in the pleading or in a submission, wherever, suppose a lawyer is making a submission, so he can put a declaration that I have used AI in this paragraph. And a classic example is Justice Chitkara himself, because in 2023, in Jaswinder's case, he has put in a bail order a paragraph giving reasons of the AI that why the what the bail consideration should be. But he was very fair. He said, I have taken this paragraph from AI, so you take note of it. The country took note of it. It went viral on social media. Each one of us were reading it, and we were slightly amazed at that time. But certainly, this could be a way out if we are using it, and if it is for the benefit of a citizen, we can use it. And I also say that Ireland is using it, UK, US, and many other countries have these propositions as ethical propositions that yes, it could be declared. A declaration can be given that such and such part of the paragraph, such and such. And we are ourselves in 2022, our Chief Justice of India has launched AI Supes, whereby giving liberty even to the extent that judgment writing to whole extent can be done, except for, of course, conclusion. So we need to work with it. I ask a simple question to the House. Can it happen? I am just asking a simple question. Please answer if you can. Can it happen that if we give 6 crore pending matters to AI, it will give 6 crore judgments tomorrow morning? I say it can happen. Then can it happen that we will approve those judgments as judges which are right and maybe disapprove or maybe recorrect them or maybe correct? So can it happen that pendency can happen zero within a period of 30 days? A simple question. I'll not say anything. Thank you, sir.
Thank you, Justice Bhati. So everything is answered by Justice Mushtaq very smartly in the logo. Look at the logo. There is a leopard cub using laptop. So that is the ease of usage, which we need. And once we need it, then everything is done. Thank you, everyone. Thank you. With the permission of chair, can we close?
Yes, thank you so much. And it was very, very interactive session and gave us a lot of thoughts, food for thoughts. So we go ahead with the use of AI with this conviction that will keep human in loop. Thank you so much.
Thank you,
The
Ladyship and
chair.
Lordships.
One answer to Suraj's.
Now you can do because session is over. So now it is between you and
I will
him.
off the days also I'll do it.
I am relieved of the being a chair now.
No, AI doesn't lie in the human sense. It may give you incorrect answers. Lie in the human sense, AI doesn't. Yes.
So in the end, thank you, Justice Mushtaq, for giving us this opportunity, especially me, for chairing this session of AI. Thank you so much. And for the hospitality. Wonderful. Thank you.
Thank you, Ladyship and Lordships, and distinguished guests.
Can give him a standing ovation in that. Mushtaq sir.
All sessions were very, very interactive, informative, very well curated also.
Thank you, Ladyship and Lordships, and distinguished guests for this wonderful, thought provoking session. We will now have a short break, and I request all my esteemed delegates to join us thereafter at 1 p.m. for the closing plenary. Kindly bear with us. Thank you.
इस इलाके में इकट्ठा है कई सारे घर जिसमें हर
Good afternoon and a warm welcome to the Honorable Governor of Sikkim, Shri Om Prakash Mathur, sir, and our distinguished dignitaries in this august gathering. I now humbly request the Honorable Chief Guest and the esteemed dignitaries permission to proceed with the closing plenary session. We will now begin the plenary session by presenting traditional khadas to our esteemed dignitaries. I now humbly request Honorable Mr. Justice A. Muhammad Mustaq, Chief Justice, High Court of Sikkim, to kindly offer the traditional khadas to. Yes, yes. Khadas to the Honorable Governor of Sikkim, Shri Om Prakash Mathur, sir. Honorable Mr. Justice A.H.M. Dilip Nawaz, Judge, Supreme Court of Calcutta, Sri Lanka. Sorry. Respected R. Venkataramani, Sir, Learned Attorney General of India. Respected Dr. S. Shivkumar, President, Commonwealth Legal Education Association. Honorable Mr. Justice Bhaskar Raj Pradhan, High Court of Sikkim, Judge. Senior Advocate Tashi Rabden Barfungpa, President, Bar Association of Sikkim. I now request everyone present to rise for the national song. I request Senior Advocate Tashirabdin Barfumpa, President Bar Association, to kindly present the welcome address.
A very good afternoon to all the dignitaries present here today. Honorable the Governor of Sikkim, Shri Om Prakash Mathurji, Honorable Chief Justice of Seychelles, Honorable Judges from the Supreme Court, Honorable Judge, Supreme Court of Sri Lanka, Honorable High Court Judges, other respected dignitaries, judicial officers, learned senior advocates, my colleagues from the bar, ladies and gentlemen. Before I begin, I wish to express my deepest gratitude for the privilege of standing before you today. As the President of the Bar Association of Sikkim, it is a moment of immense personal and professional pride to deliver this welcome address at the conclusion of such a transformative journey. We meet at a time of extraordinary significance. Yesterday, amidst the sacred vibrations of Buddha Purnima, we witnessed a historic milestone. It is no mere coincidence that on such an auspicious day, something enlightenment, symbolizing enlightenment and the departure from the past, the Honorable Mr. Justice Surya Kant, Chief Justice, Chief Justice of India, formally declared the Sikkim judiciary as the first paperless judiciary in the country. This achievement is the fruit of an unwavering vision. As the Attorney General of India, Mr. R. Venkataramani, so eloquently stated yesterday, when Kerala meets Sikkim, Midas touch happens. We see the truth of those words in the leadership of our Honorable Chief Justice A. Mohammad Mustaq, who brings the pioneering spirit of Kerala to our mountains. This Midas touch has turned vision into reality through the constant support and encouragement of our very own Honorable Mr. Justice Meenakshi Madan Rai and Honorable Mr. Justice Bhaskar Raj Pradhan. Together, they've championed this digital evolution from its very inception. Of course, as we transition to being fully paperless, we must admit that the path is paved with learning opportunities, especially for those of us who are more familiar with physical files than electronic pads. Just the other day, while appearing in a matter before the Honorable Chief Justice and her leadership in court number 1, I was attempting to navigate an online PDF. Suddenly, an online advertisement in Hindi began playing at full blast. In my nervousness to scramble to silence it, I managed to do the exact opposite and increase the volume instead of decreasing it. I looked up to see, I stood there mortified. I looked up to see a surprised but kind gesture from the bench. That simple gesture eased the pressure, reminding us that while technical glitches are inevitable, they are simply the growing pains of progress. Change is rarely easy. I recall when the e-filing system was first introduced, many within our bar were understandably reluctant to let go of the long-standing tradition of physical bundles. However, that hesitation has turned into a resolute preference today. Today, our members have embraced a new reality, the ability to file matters from the comfort of our homes or chambers at any hour of the day and night, and to appear in the courts via video conferencing has fundamentally made life easier and more efficient. No longer burdened by bulky files, we've also joined the vital movement of protecting our environment by moving away from papers. Throughout this 2 days conclave, we've navigated vital paths of inquiry, charting roadmaps from mandatory e-filing and the safe introduction of artificial intelligence, bridging jurisdiction to harmonize judicial education for a transnational era, addressing the intersection of blockchains, cybersecurity, and the ethical guardrails required for justice. As we prepare for the final reflection from Honorable Justice Bhaskar Raj Pradhan and the key takeaways from Honorable the Chief Justice, High Court of Sikkim, we are honored to have His Excellency the Governor of Sikkim, Mr. Om Prakash Mathur, join us for the valedictory address. The roadmap we've drafted here is a promise of a swifter, more accessible temple of justice. We started this conclave as a practitioner of law. We live it as pioneers of a digital future. Thank you. And I hope you all have a pleasant afternoon. Thank you.
Thank you, sir, for the speech. May I now request Professor Dr. S. Shivkumar, President, Commonwealth Legal Education Association, to kindly enlighten us with his kind observations.
Honorable Sri Om Prakash Mathur, Governor of Sikkim, Dr. R. Venkatramani, Lieutenant Attorney General for India, Honorable Mr. Justice Nawaz, Supreme Court of Sri Lanka, Honorable Chief Justice of Sikkim, Honorable Mr. Justice Muhammad Mustaq, distinguished members of the judiciary, Chief Justice of various high courts, just Honorable Mr. Justice Bhaskar Raj Pradhan, Judge of Sikkim High Court, judges of various high courts, Bar Association President Mr. Tashir Rapthan, lawyers, legal professionals, esteemed colleagues from Commonwealth, physically as well as virtually joined, Honorable Chief Justice of Seychelles, Roni Govindan, members of the bar, academia, and distinguished participants. It is both a privilege and a moment of deep reflection to offer this observation at the conclusion of what has been an intellectually rich and forward-looking conclave on technology and judicial education. Before I begin, I would like to express my sincere gratitude to Honorable Mr. Justice Muhammad Mustaq, Chief Justice, for his visionary leadership in conceptualizing this exceptional conclave along with his colleagues in Sikkim, and for enabling the meaningful participation of Commonwealth Legal Education Association, an integral part of this initiative. I must also acknowledge with deep gratitude Justice continued to support CLIA across multiple engagement, including in gracious presence and valuable contribution at our recent conferences held in Kumaragam, Thiruvananthapuram, very recently in Bangalore, which have been greatly strengthened our collective effort in advancing legal education and institutional collaboration. So interestingly, half of the High Court judges sitting here are part of CLIA movement. They used to travel together with CLIA deliberations. Now, let me begin with a brief image. A litigant travels days to reach a court, carrying a one bundle of papers. His case is called and adjourned because the file cannot be located. Now, imagine the same litigant today, no bundle, no corridor wait. His case files exist in a system accessible instantly. His presence no longer bound by distance. Between these two moments lies not just technological progress, but the promise of justice reimagined. Over the last 2 days, what we have witnessed in this conclave is precisely this transition from justice system defined by physical constraints to one increasingly shaped by digital possibility. What makes this gathering truly remarkable is that it has not treated technology as an end in itself, but as part of a larger institutional transformation. Two powerful conversations have unfolded here, distinct in focus, yet deeply interconnected. The first concern the transformation of the Indian judiciary through technology. The second concern the transformation of judicial education across Commonwealth in a digital age. Together, they remind us of a simple but profound truth that what we cannot reshape legal and justice system without simultaneously rethinking how legal knowledge and education is cultivated and sustained. The discussion on e-filing, what emerged was not just a technical roadmap, but a shift in how we defined access to justice, which is measured by usability, inclusiveness, and trust not mere availability. We are moving beyond digitalization to true process of re-engineering, not not converting paper into pixels, but questioning why process exists and how they can be simplified or redesigned. As data becomes structured, workflows intelligent, and duplication disappears, the result is not just efficiency, but institutional clarity. Discussion on blockchain pointed further ahead to a future where judicial records are not only stored, but secured in their integrity with trust embedded in the architecture. And then inevitably, we arrived at a question of artificial intelligence. There is understandably both excitement and caution. Excitement about what AI can do, organize, predict, and streamline. Caution about it must not do, which is replace human judgment, obscure reasoning, or dilute accountability. What we merge from this conclave is a balanced position. Let AI begin where it is strongest, but let the core of the adjudication remain irreducibly human. Because justice is not a calculation, it is reasoned, moral, and constitutional act. Judicial education is shifting from static instruction to interactive and adaptive learning. With the rise of virtual and hybrid courts, our legal system must combine legal knowledge and technological competence. This process also begins a critical challenge, the digital divide. If technology becomes the primary interface of justice, unequal access to technology risk becoming unequal access to justice. The Commonwealth perspective highlighted the shared challenges in regulating emerging technologies and developing ethical AI, while pointing towards a future where judicial education is strengthened by collaboration, shared resources, and collective intelligence beyond geographical boundaries. And yet, if there is one thread that runs consistently through this conclave, it is emphasis on ethics. Technology can accelerate process, it can optimize system, but it cannot on its own guarantee justice. The responsibility rests with us. We must guard against what may be termed technological determinism, meaning the assumption that efficiency alone defines progress. Perhaps the way forward lies not in choosing between tradition and technology, but in reconciling them intelligently. The true measures of judicial innovation is not speed, but fairness enhanced, right protected, and trust strengthened. Drawing from this deliberation, four clear directions emerge. Firstly, move from digitalization to transformation. Second, from the mere technology adoption to capacity building. Next, from national reforms to transnational collaboration. And finally, from the innovation to ethical governance anchored in constitutional values and human rights. Let me return in closing to the image with which I began. The litigant with the bundle of papers and the litigant with the digital file are not separated merely by time. They are separated by institutional choice. The choices we make today about technology, about education, about ethics will determine which of these two realities become the norm. If this conclave has shown us anything, it is that the future of justice is not something that will arrive on its own. It is something we must design, deliberate, and defend. Let us carry forward the insight of this conclave, not as a conclusions, but as a commitments. Commitment to innovation, commitment to collaboration, and above all, commitment to justice in its fullest sense. Thank you. Jai Hind.
Thank you, sir, for your thought-provoking observations. May I now humbly request Honorable Mr. Justice Bhaskar Raj Pradhan, Judge, High Court of Sikkim, to kindly provide His Lordship's valuable insights of this enlightening conclave.
Namaste and good afternoon. Honorable Governor of Sikkim, the illustrious dignitaries on the dais and off the dais. These 8 sessions, which we have had over a period of 2 days, has been, for me, an immense journey. It has actually motivated me to think. And the thoughts that have come from these discussions, I think, is path-breaking. We have had very, very divergent thoughts, but the resolve has been absolutely certain. We need to do something. And that is, I think, important takeaway in these sessions. The resolve, as I saw, that justice cannot be denied. And that is very important for all of us to know. Through all these sessions, I notice even divergent thoughts, some very, very controlled and some very, very path-breaking. But in both these divergent thoughts, that resolve was very, very eminent. I would be failing in my duty if I did not thank you all for the amount of energy that you have expended on these sessions. The travel that you have taken across the country from every corner of India and abroad to come and deliberate on these issues in a small state like Sikkim. I think it is important for us to understand that in these 2 days of absolutely path-breaking sessions, we have had a significant moment in the continuing evolution of the Indian judiciary and the wider Commonwealth judicial community. The exchange of ideas between the chair, the moderators, panelists, discussants, and the domain experts present has been profound. I am of the opinion that the setting has been both intellectually serious and symbolic important. I think we have more clarity in how effectively to use technology and artificial intelligence to aid our judicial processes. The conference demonstrates that in future, justice will be more dynamic, shaped not only by legal doctrines, but equally by technology, education, ethics, and constitutional values. Technology is no longer an option, administrative tool, but not part of the judicial infrastructure. These discussions over the last 2 days reflects the judiciary's mature understanding that delays often arise from lethargic and careless systems, and it can be corrected without further delay. It also reflects the judiciary's solemn resolve to administer justice more efficiently and effectively. The judiciary is definitely entering a new phase. We are in the process of redesigning institutions. We are in the process of telling the people that we care. If this process of profound transition is guided by constitutional morality and human sensitivity, this conference may be seen in time as a defining moment and to take us to the next generation. Jai Hind and thank you.
Thank you, Lordship, for your valuable perspective. May I now humbly request Honorable Mr. Justice A. Muhammad Mustaq, Chief Justice, High Court of Sikkim, to kindly share Lordship's insights on the key takeaways from this conclave.
Uh, I don't want to stand between you and lunch. As brief as possible. It's only reflections, but I remain here to express my deepest gratitude to all of you, especially all the Chief Justice. You have nominated your members here. And this first time, the Sikkim is witnessing such a galaxy of intellectuals assembling at one place and discussing about it. I must thank Honorable Governor Athochi for gracing this occasion, valedictory occasion. All Chief Justices are here, Chief Justice of Seychelles here. So it is a proud moment for all of us. Well, I must say that this conference is a result of collaboration between bar and bench. It is impossible for a small state like Sikkim with the 3 judges to host conferences like this. So you see the kind of collaborations happen all level, even building e-filing module. I must say that Mr. Tazi is part of the technical team. Come here, Tazi. So we may give him a big round of applause. The last 3 weeks he was working with IT team as like he was part of the Sikkim High Court team. So today also see the last 2 days he was engaged vigorously in holding the various sessions. So it is all because of this collaboration among the all stakeholders, and especially the government also supported us immensely to bring to bring best result of this conference. So once again, I thank each one of you attending this conference. Thank you one and all. Jai Hind.
Thank you, Lordship. May I now humbly request Honorable Mr. Justice H.M. Nawaz, Judge, Supreme Court of Sri Lanka, to kindly deliver the special address.
Honorable Governor of the beautiful state of Sikkim, the Honorable Attorney General of India, the energetic Chief Justice of Sikkim, Mustaq Mohammed, of course, the effervescent judge, Honorable Judge, who spoke so glowingly of the preparations, and of course, the evergreen Professor Sivakumar, who has been actively promoting knowledge sharing in the Commonwealth, and my good friend over there. I must also address the distinguished gathering here, the Chief Justices of Delhi, the Chief Justice of Seychelles, who has flown all the way from that beautiful land of beaches and sand, which I'm yet to savor, and all my other friends, judicial friends, High Court judges, district judges, the academicians who add spice to our work, who are here, whom we heard, and of course, all that distinguished members of the legal fraternity. As we come close to the closure of this session, various thoughts flash across my mind. Honorable Attorney General of India, Mr. Venkataramani, just introduced me to somebody as a friend of India. I was reflecting on that proposition, that introduction. Having traveled to India for nearly so many years, I can't even count the number of years, and I think my passport bears stamps of the Indian immigration more than the stamps of any other country. When I look at it, I feel this connectivity to this great subcontinent. This continent has provoked a lot of thoughts across the globe. I must say that I was fed as a youngster on Indian films, Indian soap operas, movies, and Indian songs. I remember how we cut school to watch that famous film called Abhiman in my youthful days, and I still get fascinated by those lilting songs of those good old days. So it's no wonder, therefore, given this long connectivity, you get aligned to a great country of India, where we also have mythological connections when that beautiful lady Sita was abducted by somebody, and then we know the rescue operations, and then so this makes us feel part of India. And today, Mr. Justice Mustaq Muhammad, you should be congratulated for bringing us from various parts of the Commonwealth to put together this wonderful assembly. And of course, this young gentleman who is here, the evergreen Professor Sivakumar, must take cues from this conference and take it forward. Inject a lot of ideas that have cropped across the several dominant themes that we discussed today, and make it a permanent avenue for knowledge sharing in the future. So all in all, it was a meeting of great friends, meeting all of them in a setting which is so convivial, a setting which brought us together in a spirit of friendship. And I must thank the organizers. I must thank the team and the young team that is also behind, and everybody involved in this to make it a success. So my reflections are of a journey well traveled, though it was a very hectic journey all the way from Colombo, a sleepless night. But of course, that was compensated for by this lively exchange of intellectual input. We judges have this unholy task of deciding what we call truth, but we insist on proof. Sometimes truth doesn't come out, but what we insist on is proof. Today, that tools of proof as to how we should employ those tools of proof were explored at a point when this profession, judicial as well as legal, are both at the crossroads. As I looked at the map of Sikkim, as it surrounded by nations of wide hues, and I certainly feel Sikkim today sits not only at the crossroad of several nations, but also at the crossroad of cross-cultural legal ideas. So it was in that beautiful setting that you had this, the learned High Court judge of Sikkim, Justice Mustaq. And it was our pleasure that our great friend of South Asian judiciaries, your own Chief Justice of India, Justice Suryakant, set the stone yesterday. We have torn for this great program to evolve, and I only hope and trust with the passage of time, the stimulus that has been given today over the last 2 days will motivate us, goad us to achieve perfection, and in the process, all of us go away richer for the golden opportunity that this conference presented to us. So thank you very much to all of you for wonderfully set this beautiful setting in which we deliberated upon the issues. So thank you.
Thank you, Lordship, for the warm and inspiring words. It is now my great honor to request the Honorable Governor of Sikkim, Shri Om Prakash Mathur Sir, to address the gathering for the valedictory address.
चिंतन भवन में इस सभागार में उपस्थित भारत सरकार के अटॉर्नी जनरल श्री आर के वेंकटरमन, श्रीलंका के सर्वोच्च न्यायालय के न्यायमूर्ति श्रीमान AHMD नवाज, उच्चतम न्यायालय के उपस्थित न्यायमूर्तिगण, सिक्किम उच्च न्यायालय के मुख्य न्यायाधीश श्रीमान A मोहम्मद मुश्ताक, विभिन्न राज्यों से पधारे उच्च न्यायालयों के मुख्य न्यायाधीश एवं न्यायाधीशगण, सिक्किम उच्च न्यायालय के न्यायमूर्ति श्री भास्कर प्रधान, कॉमनवेल्थ लीगल एजुकेशन एसोसिएशन के अध्यक्ष डॉक्टर S शिव कुमार, सिक्किम बार एसोसिएशन के अध्यक्ष श्रीमान ताशी राप्तेन एवं उपस्थित न्याय व्यवस्था और कानून से जुड़े सभी प्रबुद्धजन, देवियों और सज्जनों, जैसा कि मुझे ज्ञात हुआ है कि न्यायिक शिक्षा और प्रौद्योगिक शिक्षा विषय पर पिछले 2 दिनों में अनेक सत्रों में विचार विमर्श हुआ है। इस महत्वपूर्ण सम्मेलन के समापन सत्र में हिमालय की गोद में बसे इस अनुपम सौंदर्य से भरे प्रदेश सिक्किम में आप सभी का हृदय से स्वागत करता हूं। सिक्किम उच्च न्यायालय और सिक्किम न्यायिक अकादमी द्वारा आयोजित इस प्रौद्योगिक और न्यायिक शिक्षा सम्मेलन का ये कार्यक्रम भारतीय लोकतंत्र व्यवस्था के स्तंभों में से एक महत्वपूर्ण स्तंभ को समझने और परखने का अवसर है। ये सम्मेलन हमारे न्यायिक तंत्र को सशक्त बनाने की दिशा में एक महत्वपूर्ण पड़ाव है। अतीत से लेकर वर्तमान तक भारतीय न्यायिक प्रणाली ने समाज को दिशा दी है और लोकतंत्र के स्तंभ के रूप में अपनी भूमिका निभाई है। यह सम्मेलन केवल तकनीकी और न्यायिक शिक्षा के बीच संबंध स्थापित को समझने का अवसर ही नहीं है, बल्कि यह भविष्य की न्यायिक प्रणाली को और अधिक पारदर्शी, कुशल, सुलभ बनाने की दिशा में एक ठोस कदम भी है। आधुनिक तकनीकी के प्रयोग से न्यायिक प्रक्रिया में तेजी आएगी, न्याय तक पहुंच आसान होगी और न्यायाधीशों और विधि विशेषज्ञों को नवीनतम ज्ञान से सशक्त किया जाएगा। यह सम्मेलन भारतीय लोकतंत्र के न्यायिक स्तंभ को और मजबूत करने का मार्ग प्रशस्त करेगा। न्यायिक उत्पादकता और पारदर्शिता को बढ़ाने के लिए ई प्रक्रियाएं, कागज रहित न्यायालय, डिजिटल रिकॉर्ड, ई फाइलिंग, हाइब्रिड न्यायालय, लाइव स्ट्रीमिंग जैसी तकनीकों का प्रयोग न्यायिक प्रणाली को आधुनिक बनाने की दिशा में एक क्रांतिकारी कदम है। इन पहलों से न केवल न्यायिक कार्रवाई की गति तेज होगी, बल्कि नागरिकों को न्याय तक पहुंचने में अधिक सुविधा और पारदर्शिता मिलेगी। इन तकनीकी नवाचारों से नागरिक केंद्रित सेवाएं सुलभ होगी, जिससे हर व्यक्ति को न्यायिक प्रक्रिया में समान अवसर और सहभागिता का अनुभव हो सकेगा। यही नहीं, यह पहल न्यायपालिका को समय की मांग के अनुरूप ढालने और लोकतंत्र की नींव को और अधिक सुदृढ़ करने में सहायक सिद्ध होगी। आज जब समाज तेजी से बदल रहा है, तब न्यायपालिका भी समय के साथ कदम मिलाकर चलने की दिशा में अग्रसर है। तकनीकी साधनों का उपयोग केवल सुविधा का माध्यम नहीं, बल्कि ये न्यायिक व्यवस्था को अधिक उत्तरदायी और नागरिकों के प्रति संवेदनशील बनाने का साधन भी है। इस सम्मेलन के माध्यम से हम न केवल वर्तमान चुनौतियों का समाधान खोज रहे हैं, बल्कि आने वाले समय के लिए एक ऐसी न्यायिक व्यवस्था का निर्माण कर रहे हैं जो पारदर्शिता, दक्षता और समानता के मूल्यों पर आधारित होगी। यही वह दृष्टि है जो भारतीय लोकतंत्र को और अधिक सशक्त बनाएगी। आज का ये संगम तकनीकी नवाचार, न्यायिक शिक्षा का भारतीय लोकतंत्र के न्यायिक स्तंभ को नई ऊर्जा प्रदान करेगा और आने वाली पीढ़ियों के लिए एक न्याय संगत, पारदर्शी और सशक्त व्यवस्था का मार्ग प्रशस्त करेगा। यह अवसर हमारे राज्य के लिए ऐतिहासिक है। जैसा कि मुझे ज्ञात हुआ है, सिक्किम को भारत की पहली पूर्णतः कागज रहित न्यायपालिका घोषित करने की दिशा में निर्णायक कदम उठाया गया है, तो वास्तव में डिजिटल इंडिया के व्यापक दृष्टिकोण को साकार कर रहे हैं। यह पहल न्यायिक प्रणाली को आधुनिक युग की आवश्यकताओं के अनुरूप ढालने का प्रमाण है। यह परिवर्तन का उद्देश्य केवल फाइलों को कंप्यूटर में बदलना नहीं, बल्कि लंबित मुकदमों के बोझ को कम करना और न्याय की प्रक्रिया में मानवीय पक्ष को और अधिक सशक्त बनाना है। यह बदलाव तकनीकी को अपनाने तक सीमित नहीं है, बल्कि ये न्याय प्रणाली को अधिक पारदर्शी, पर्यावरण के अनुकूल और आम नागरिक के सुलभ बनाने की अटूट प्रतिबद्धता का प्रतीक है। डिजिटल न्यायपालिका के माध्यम से हम न्याय की गति को बढ़ाने और इसे समाज के अंतिम व्यक्ति तक पहुंचाने का संकल्प सिद्ध कर रहे हैं। आज के युग में न्यायपालिका और प्रौद्योगिक एकीकरण समय की मांग है। आर्टिफिशियल इंटेलिजेंस और डिजिटल प्रबंधन जैसे आधुनिक नवाचार अब केवल विकल्प नहीं, बल्कि न्याय प्रणाली को सुदृढ़ करने के अनिवार्य स्तंभ बन चुके हैं, जो हमारे न्यायिक अधिकारियों को जटिल कानून चुनौतियों और साइबर युग की समस्याओं से निपटने में सक्षम बनाएंगे। न्यायिक शिक्षा में तकनीकी का समावेश न केवल कानूनी प्रक्रिया को सुव्यवस्थित करेगा, बल्कि हमारे भविष्य के विधिक नेतृत्व को भी सशक्त बनाएगा। मुझे पूर्ण विश्वास है कि इस सम्मेलन के माध्यम से विधि विशेषज्ञों और प्रौद्योगिकविदों के बीच होने वाला विचार विमर्श न केवल हमारे विधिक ढांचे को आधुनिक बनाएगा, बल्कि आने वाली पीढ़ियों के लिए एक न्यायपूर्ण और डिजिटल रूप में सशक्त समाज की नींव रखेगा। इस सम्मेलन के समापन अवसर पर मैं आप सभी का हृदय से आभार व्यक्त करता हूं। बीते 2 दिनों में हमने प्रौद्योगिक और न्यायिक शिक्षा के विभिन्न पहलुओं पर गहन विचार विमर्श किया है। यह सम्मेलन केवल एक चर्चा का मंच नहीं, बल्कि भारतीय न्यायपालिका को भविष्य की आवश्यकताओं के अनुरूप ढालने का एक ठोस प्रयास है। न्यायिक प्रणाली से जुड़े सभी हितधारकों को एक साझा मंच लाकर हम बाधाओं की पहचान कर उन्हें दूर करने की दिशा में ठोस कदम उठा सकते हैं। यह प्रयास न्यायिक व्यवस्था को अधिक सशक्त, आधुनिक और लोकतांत्रिक बनाने की दिशा में एक निर्णायक कदम है। इस महत्वपूर्ण अवसर पर मैं सभी समक्ष न्याय व्यवस्था के समानता और सुलभता सुनिश्चित करने हेतु कुछ सुझाव रखना चाहता हूँ। न्यायिक प्रणाली में स्थानीय भाषा को प्राथमिकता दी जानी चाहिए, ताकि लोगों को किसी प्रकार की असुविधा न हो। इसमें अनुवादक की सहायता ली जा सकती है। कैसे कर पाएंगे, कैसे नहीं कर पाएंगे, लेकिन मेरी बहुत दृढ़ मन में इच्छा है कि जहाँ जहाँ हम न्याय की व्यवस्था तो लोकल अगर भाषा में उसको कुछ कर सके। आजकल तो ऐसे ऐप भी आ गए कि आप जो बोलेंगे अगला वो चाहेगा वो सुन सकता है। अगर इसका भी उपयोग करें या अनुवादक का उपयोग करें, तो इसमें नीचे तक लोगों को न्याय प्रणाली को समझने का, क्या बोला है क्या नहीं वकील ने तर्क किया है, उसकी जानकारी भी उसको मिल सकती है। वर्तमान समय में कुछ उच्च न्यायालयों द्वारा न्यायिक कार्रवाई को विभिन्न माध्यमों द्वारा सार्वजनिक किया जाता है, जो एक बेहतरीन पहल है। इसके माध्यम से आमजन एवं युवा अधिवक्ता न्याय व्यवस्था को आसानी से समझ रहे हैं। साथ ही ये देखा गया है कि कुछ लोग व्यक्तिगत प्रचार एवं प्रोपेगेंडा के लिए उस कार्रवाई को सोशल मीडिया पर प्रसारित करते हैं। मेरा अनुमान है कि इस प्रकार के कृत्य को आपराधिक मानकर उसके लिए कड़ा प्रावधान करना चाहिए, जिससे इस प्रवृत्ति पर रोक सके। मैं लगभग 55-56 वर्षों से सामाजिक जीवन में हूँ। कई बार न्यायालय की कोई जो रूलिंग आती है, उसको कई प्रकार का दुष्प्रहार भी किया जाता है। तो हम इस पर कितने कठोर व्यवस्था कर सके, ताकि सोशल मीडिया के माध्यम से वो इस प्रकार का दुष्प्रचार नहीं करे। जमानत आदेश तथा अत्यावश्यक प्रकार के आदेश उच्च न्यायालय द्वारा पारित होने के कुछ ही समय के भीतर ही अधीनस्थ न्यायालयों को भेजे जाने चाहिए, ताकि अत्यावश्यक आदेशों के क्रियान्वयन में शीघ्रता लाई जा सके। युवा अधिवक्ताओं को प्रकाशित निर्णय की निःशुल्क पहुंच उपलब्ध कराई जानी चाहिए। मुझे पूरा विश्वास है यहाँ से निकलने वाले निष्कर्ष भविष्य के विकसित भारत की न्यायपालिका के लिए एक मार्गदर्शक प्रकाश स्तंभ का कार्य करेगा। आइए हम सब इस तकनीकी क्रांति को अपनी संवैधानिक मर्यादाओं और नैतिक मूल्यों के साथ जोड़कर एक नए न्याय युग का सूत्रपात करें। ये न्याय युग न केवल न्यायपालिका को सशक्त करेगा, बल्कि नागरिकों के विश्वास और लोकतंत्र की नींव को भी मजबूत करेगा। धन्यवाद। जय हिंद, जय सिक्किम।
Thank you, Honorable Governor, sir, for the warm words that inspire us. I now request the learned Central Project Coordinator, High Court of Sikkim, Mrs. Sonam Denka Wongdi, Madam, to propose the closing acknowledgements.
Good afternoon, everyone. Honorable Governor of Sikkim, Honorable Chief Justices, and Honorable Justices of all the High Courts of this country, Honorable Chief Justice, Supreme Court of Seychelles, Honorable Judge, Supreme Court of Sri Lanka, respected dignitaries on and off the dais, esteemed judicial officers and educators, distinguished speakers, clear members, our friends from National Judicial Academy, learned senior advocates, and members of bar associations of Sikkim, erudite participants. It gives me immense pleasure and honor to offer my acknowledgement and gratitude on behalf of the High Court of Sikkim and Sikkim Judicial Academy. I am deeply privileged indeed. As the German economist Klaus Schwab aptly observed, I quote, "We are in the midst of a technological revolution that will fundamentally alter the way we live, work, and relate to one another," unquote. Over the course of the two conferences, we have witnessed how this transformation is reshaping judicial systems and redefining the role of judicial technology in both India and across the Commonwealth. I would like to express my humble gratitude to the Honorable Governor Sri Om Prakash Mathurji for gracing this valedictory function and for delivering such an insightful and inspiring address. Your words have reinforced the importance of impressing technology to strengthen access to justice and institutional efficiency. Thank you, sir. Our sincere appreciation goes out to all the distinguished panelists, judicial luminaries, experts, and resource persons who have shared their valuable knowledge and experiences. Your deliberations on digital courts, artificial intelligence, e-governance, innovative projects, and judicial training have greatly enriched both the conferences. Thank you also, I must add, for braving the long journey to be here with us. We appreciate it deeply. We are equally grateful to the state government for their support has been instrumental in making both the conferences insightful and forward-looking. In this regard, special mention may be made of the Home Department, the liaison officers, and the Police Department. I will fail in my duty if I do not express my sincere gratitude and appreciation to the learned Registrar General, Registrar Judicial Service, Member Secretary, Sikkim State Legal Services Authority, Director and Deputy Director of Sikkim Judicial Academy, the learned advocates, and the support staff from the High Court of Sikkim, Sikkim State Legal Services Authority, and Sikkim Judicial Academy for their dedication, meticulous planning, and seamless execution for ensuring success of both the conferences. Thank you especially to my computer team of High Court of Sikkim for helping us achieve and execute what we dreamt of by becoming the first paperless state judiciary in the country. May we continue to work hard and strive for the best for our institution. At the end, my address would be incomplete if I do not extend special thanks to Honorable Mr. Justice A. Mohammed Mushtaq, Chief Justice High Court of Sikkim, Honorable Mrs. Justice Meenakshi Madan Rai, and Honorable Mr. Justice Bhaskar Raj Pradhan, judges of the High Court of Sikkim, for their valued guidance and inspiration in making the programs a success. As we conclude, we carry forward not only the knowledge and ideas shared here, but also the renewed commitment to leverage technology for the transformation of judiciary and strengthening judicial education in the digital age across our nations. With these words, I once again thank each one of you for a valuable presence and contribution, and I wish you all a safe and pleasant journey ahead. Thank you all. Jai Hind.
Thank you, ma'am. Before we rise for the national song and national anthem, we would be grateful if the learned Attorney General of India, R. Venkataramani, sir, would kindly grace this august gathering with his thoughts.
sandwiched between the Honorable Governor and the Chief Justice, Sikkim. If the Attorney General does not give a vote of thanks, this conclave will not have a great ending. I am, with the best of my sincerity and the warmth of my heart, I wish to pray a word of thanks, but a different word of thanks. As I was listening the past 2 days, and we're planning this conference and conclave, thanks to CLEA being part of an Indian soil today, it will continue to remain as part of Indian soil for some more time. We are going to retain CLEA as an imprisoned category of intellectual engagement throughout for some more time. And there's going to be a great resolve. And this conclave, like us remembering poet Shelley's ode to the Grecian urn, this conclave is an ode to Sikkim. This conclave is a great ode to Sikkim. And Sikkim will always feel proud about what it has done yesterday and today. And finally, I was remembering Justice Krishnaya. If only he had been here, he would have coined a nice word. Probably I could have coined the same word. Something like a techno-justiciology. We're all on a techno-justiciology journey. And I'm sure this journey will be a great journey. And I promise to each one of our honorable judges who come here that this office and the CLEA will travel as long as possible, tirelessly. And I remember once again, my first brief when I entered the profession was a legal aid brief, and a poor scheduled caste woman who lost her land fighting against an MLA. I asked myself a question, what is justice doing? I continue to ask my question. All of us keep asking the question as lawyers, as judges. I'm sure that we will travel together. And I must thank Justice Mushraq for calling me here today and sitting in the presence of Honorable Governor. Sir, let us travel, make Sikkim and top of India. So,
Thank you, sir, for the kind words. It was a pleasure hearing your thoughts. I now request everyone to rise for the national song followed by the national anthem.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Honorable Governor Sir, Honorable Lordships, and esteemed delegates, as we near the end of this conclave, we thank you for your valuable contributions. We are also deeply grateful for your presence, which added immense value to this occasion. Thank you and wish you a pleasant afternoon. The organizers are now requested to escort all the distinguished dignitaries for lunch.